Mr. Garber, did you have a chance to review that?
I did, Judge. Thank you.
Mr. Williams, would you like to, again, explain your objection and what you believe the statement should say?
It's the state's position that the fact that a witness did not relate material information in one statement and then did in another is ripe for argument on the veracity or credibility of the statement. So to the extent that that statement, the instruction that the court gave is inconsistent, the state objects to it.
Okay.
And yes, Judge, our position is that he never gave an inconsistent statement because he wasn't asked about it.
His argument isn't that it was an inconsistent statement. He's saying that there was additional material information provided. That's the argument, not that it's inconsistent.
Which he was never asked about. And as we established yesterday, Judge, as Mr. Williams knows, in courts in this country, lawyers ask the questions, witnesses give answers. It's entirely inappropriate against the law and against rules of courtroom decorum for witnesses to just start talking to the jury and giving a narrative. He wasn't asked about it, so of course he can't speak on it. So once the state puts that in front of the jury, saying, hey, he's less credible now, just because he wasn't asked a question, is no fault of his own, Judge, and it's completely burden shifting. If he didn't ask a question, how can he possibly answer, Judge? So we think the curative instruction's been given. We think it's appropriate. We think there's no way that it could be rescinded without causing all sorts of confusion and chaos to the jury. And so we think that it should stand and we should move past this issue.
May I work on the AD while Lauren's considering this?
Absolutely.
Sure, I just didn't want to.
Here, point seven.
read the instruction the way that it is, but here's what I'll tell you regarding the argument that you presented. I think it's proper for counsel to be able to argue that there was additional information or evidence presented after all the testimony had been closed that was not previously testified to. I think that's different than arguing that you're not able to argue that he didn't provide information to questions that were not posed.
I understand the distinction, and I will make sure I argue both.
Judge, we would just object to them being able to raise that at all because that creates an improper inference and an improper idea in the jury's mind that he is less credible for giving rebuttal testimony when, of course, it was new to Judge because they called a rebuttal witness. So then, of course, it's not improper for us to then clarify a brand new issue that they raised, not us, and it creates an improper inference that he is somehow less credible because the state won rebuttal, forcing us to on rebuttal, and that he did not provide information that he was never asked about. We believe it's burden shifting. We think that Your Honor should instruct the state not to mention it at all.
Okay, your objection is noted. Mr. Crawford became a witness in the case. The jury is able to evaluate his credibility and testimony just like any other witness. And he testified yesterday for a very long time and had an opportunity to tell his story. And I think that the state is able to comment on the additional testimony that the defendant provided. But like I said, they're not able to argue that he did not provide information to questions that were not posed to him.
Just for clarification, is the state allowed to argue to the jury that he is somehow less credible because of the new information was not provided before when he wasn't asked about it? Is he allowed to make the credibility argument?
They can make an argument that his rebuttal testimony is not credible, not because he didn't answer questions that were not posed to him, but they can argue, you can argue the credibility of any witness's testimony.
Right, Judge, but I think based on the ruling, we're saying, well, they can't mention that, well, he didn't give information he wasn't asked about, but they can say, well, you didn't hear this information. I don't see how the two aren't inextricably
Well, I think there's
intertwined.
another proper argument that can be made. You can make the objection you want to, and Mr. Lynn's making the argument, but I said clearly what the reason is.
I understand, Judge.
We'll leave it at that.
Okay, thank you.
All right. So that was the housekeeping matter that I had, correct?
I have one additional one. It's very quick, Your Honor. Yesterday, when I was just renewing objections, but during instructions for record purposes, preservation purposes, there was one that I am not 100% positive I got on the record, and that is I also need to renew my objection for your denial of my request to have the definition of culpable negligence as provided in the Randall, Arnold, and Kish states that we cited, which specifically states there has to be a conscious action. Thank you, Judge. Yes.
And then, Jeff, will you come grab the other copies for the application, please? If you'll just give me that for the one right here. Yeah, thank you. Yes, please. Thank you. Yes.
Judge, I think we were supposed to have a copy for both of us. You had said we just have the one. I approach you. I just want to make sure you're
You should have.
Thank you. May I approach, Judge?
May.
Thank you. Thank you so much.
saturate.
Good morning. Good morning. You made it. It's Friday. Yes. Did you all adhere to the instruction I gave you last night again to not watch the local news, not do any research about the case, not discuss it amongst yourselves or with anyone else?
Yes.
Okay. Thank you. So at this time, we are going to proceed with going over the jury instructions. I put a copy on your chairs. You all should have one there. If you want to follow along with me, great. If you do follow along, I just ask that you stay with me so that we're all on the same page. You certainly don't have to. And you will also be able to take this into the jury room with you while you're deliberating, okay? Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. David Thomas Crawford, the defendant in this case, has been accused of the crime of culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt. David Thomas Crawford inflicted actual personal injury on Jean Baretto-Baerga. He did so through culpable negligence. I will now define culpable negligence for you. Each of us has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or shows such an indifference to the rights of others as is equivalent to an intentional violation of such rights. A law enforcement officer or any person he has summoned or directed to assist him need not retreat from or stop efforts to make a lawful arrest because of resistance or threatened resistance to the arrest. The officer is justified in the use of any force that he reasonably believes necessary to defend himself or another from bodily harm while making the arrest. That force is also justifiable when necessarily used in retaking a felon who has escaped or in arresting a felon who is fleeing from justice. A law enforcement officer or other person who has an arrested person in his custody is justified in the use of any force that he reasonably believes to be necessary to prevent the escape of the arrested person from custody. Every Osceola County Sheriff's deputy is an officer within the meaning of the law. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proven beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. Some evidence may be admitted only for a limited purpose. When I instruct you that an item of evidence has been admitted only for a limited purpose, you must consider it only for that limited purpose and not for any other purpose. An item was received into evidence as Defense Exhibit 1. This item of evidence may be considered by you only for the limited purpose of assisting you in determining the manner in which Jean Baretto-Baerga operated his motorcycle and how that affected the temperature of the dirt bike driven by Jean Baretto-Baerga and whether that could have caused the fire in this case. Defense Exhibit 1 may also be considered by you for the additional limited purpose of assisting you in determining whether Jean Baretto-Baerga was aware of the presence of the Star Aviation Unit or the helicopter. You should disregard the evidence for any other purpose. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. The case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever your verdict you render, it must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by your feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you, which I do have here. This verdict form will go back with you into the jury room, and it just has two spaces here. It says, we the jury find the defendant guilty of culpable negligence as charged in the information. We the jury find the defendant not guilty, so say y'all. It's going to be signed and dated by the foreperson, okay? And at this time, we are going to proceed to the closing arguments. The attorneys will now present to you their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. If your recollection of the evidence is different than what the attorney says, please rely on your own recollection. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. Ms. Williams?
Yes, Ma'am.
All right, you may proceed.
Thank you. May I please report, Counselor? The defendant, Deputy David Crawford, ran headlong into a man pumping gas, knocking him over and spilling fuel all over the ground. He paid no attention to the innocent bystanders that he passed as he went on his way to perform this act. Despite being surrounded by pools of gasoline, the defendant then pulled out a taser and discharged him. He knew there was gasoline all over the place. He announced it. He knew he was going to fire the taser. He announced it. But for dumb luck, the 9-year-old and his father would have burst into flames because of the defendant's actions that day. But for the quick actions of bystanders.
We approach.
But for the quick thinking of civilians who grabbed fire extinguishers and put out the fire before it could spread, everyone at the gas station was at risk that day. But there was no luck for Jean Baretto-Baerga. his life, his body, are changed forever. The evidence shows that on February 27th of 2022, this defendant was not protecting anyone. He had time. He had help. There was absolutely no reason why the events that went forward that day had to end in a fire. The only reason they ended the way they did, with dozens of people put at risk and one man burned over 65% of his body, is solely because of the actions that he chose to take. Not one, but multiple actions over the course of time. That is the evidence that you have heard over the course of the last 4 days. So now I'd like to spend a little bit of time talking to you about the elements in this case that it's the state's burden to prove beyond a reasonable doubt, and how the evidence in this case allows us to meet that burden. So every crime has elements, and the state's burden is to prove each and every one of them to the exclusion of any reasonable doubt. And there's no difference with culpable negligence with personal injury. The instruction for that, as the court has read and as you have in front of you, requires us to prove two things that are on the screen in front of you. But I will say that the first one is actually two things in and of itself when you really look at it. The first part is that David Crawford inflicted personal injury on Jean Baretto-Baerga. The first thing we have to prove is that the victim was in fact injured, though I do not believe there will be much of a dispute about that fact. You all saw multiple videos that showed Mr. Baretto-Baerga on fire, in flames, running immediately after the defendant, as the evidence shows, discharged the taser. You saw the injuries that he suffered immediately thereafter. You heard Deputy McLean, I believe it was, describe how the skin was literally falling off his body as he sat next to the gas station. You saw the photographs of the victim immediately after he was burned at the hospital. And you saw the medical records, and I should say that all of the evidence that I'm showing you will be in evidence and will be given to you at the end of the trial so you can review it for yourselves, including the medical records. And I put this record up on the screen during the state's case. I didn't expect you all to read every bit of it, but when you really look at it, it's not just that he was burned over 65% of his body. Just in this record, which stops in July of last year, he had 6 surgeries, and he can no longer properly use his shoulder or his elbow because of the burns that were
Objection, Your Honor.
inflicted upon.
May we approach?
In short, there's evidence beyond a reasonable doubt that the victim in this case is injured and suffered injury. The second part of the first element is that the defendant is the one who inflicted the injury, right? Because he has to be proven to be the one that inflicted the injury on the victim. So again, I would submit to you that there's no real dispute that the defendant fired the taser in this case. Ms. Walker spent a lot of time with deputies and Brian Childs from Axon going through the video in this case and matching up the video with the Taser logs in this case. And I'm not going to show you all that again because you all saw it and I'm not going to waste your time. It's in evidence, but the description that Mr. Childs gave in the video that you saw shows, and this is the body camera from the defendant, 17:55:59. You see the spark begin. You see the discharge of the Taser at 17:53:57. 2-second time lapse from the Taser with the drift that was discussed by Mr. Childs. Even without the millisecond data that you have, the video pretty clearly shows anyone with common sense that the fire starts in the location and at the time that the trigger is pulled. The person holding, the last person on video holding that Taser was the defendant. Right hand to left hand, and a moment later, boom. It matches with the video, it matches with the Taser and the Axon data. So you have the video and you have the Axon data. But the state went a step further and also eliminated other reasonable possibilities that could have been the cause of this fire but for the defendant. Because you heard from Detective Kamini from the Bureau of Arson Investigations and Fire. So what did Detective Kamini say? He was very transparent and he said his job was to make sure that he considered all reasonable hypotheses. And he laid out 4 that were possibilities. And he told you that the primary culprits, other than the one he concluded was the most probable cause of the fire, was that the engine from the bike or the engine from the Camaro, the vehicle right next to the defendant when he discharged the Taser, would have caused the fire. And he went through and explained to you why that was not possible. One reason I've already mentioned, which is the fact where the actual fire started. You can see the fire begin on the left side of the pumps and not on the opposite side of the pump where the dirt bike was. That is clear, and that was Detective Kamini's conclusion. He described for you why the Camaro could not have started the fire, and defense counsel's evidence actually supported that, because if you remember seeing the infrared camera from the helicopter, the Camaro was not even hot. So it could not have started the fire. Not to mention that he explained that it would have been at a different level than where the actual fire started. Detective Kamini also discussed the fact that the timing of the fire was key, because if the bike was hot enough to spark the fuel vapors, it would have done it as soon as it tipped over when it was at its hottest before it had further time to cool. And that did not happen in this case. Same thing with the Camaro. If it were hot enough, the timing of it did not make sense. And then Detective Kamini went through in detail with the photographs of the bike itself. If the bike had caused this fire, none of this rubber or the aluminum from the radiator would be here. If you look at this photograph taken almost pristine condition, this is where the engine is, and all the rubber is intact, inconsistent with a fire starting there and burning through the rest of it. We also presented evidence to ensure that the Taser, a discharge, an accidental discharge, and by accidental I mean falling on the ground, discharge didn't cause the fire. There is no evidence, and in fact Mr. Childs, the expert who not testify as an expert, the engineer who testified from Axon.
Object to referring to him as an expert. He wasn't qualified.
Overruled. Testified about all his detailed and extensive workings with the Taser, and is unaware of any accidental discharges because it strikes the ground. But again, you have to go a step further. Because the testimony in the case, in fact, the defendant's own testimony, was that he flipped the safety on, disarming the weapon when he picked it up. And the taser will go back with you in evidence, not the battery or anything else, but just the taser. And you'll be able to see the way the safety works on both sides. Down is disarmed. In other words, down is safe. Right? It's not just that David Crawford could have accidentally pulled the trigger. You had to manipulate the safety. You have to switch the safety up to arm the taser. It was not an accidental discharge. According to the forensic evidence and the expert testimony of the arson investigator in the case. And finally, you know that the defendant was the one who discharged the taser because he said he was going to do it. He picks up the taser, he transfers it to which hand? His dominant hand that he uses to fire it. And in between doing that, he says, "You're going to get tased again." Now, I understand that they have a different theory or explanation for that statement, and I'll address that on rebuttal, because as the judge told you, I get to make the first argument and then I address their arguments, and that's when I'll do that. But I would submit to you that in that very moment, the defendant's intentions were crystal clear. He thought the victim was still struggling. He picks up the taser, announces exactly what he's going to do. The data says he armed the firearm by taking off the safety, and the trigger is pulled. It is that simple. That's the evidence that you've heard. Overwhelming evidence from multiple sources, testimony, forensic, digital, showing that the defendant was the one who discharged the taser that injured Jean Baretto-Baerga. So, the second aspect of what the state has to prove is that the defendant created this injury through culpable negligence. We do not have to prove that David Crawford intended to burn Jean Baretto-Baerga. That is not the evidence. I am not arguing that to you. The state of Florida is not putting that forward. It is that he was culpably negligent. He was so reckless in what he did that day that he caused the injuries that he did, endangering the lives of other people. So, in front of you is the definition that's in your instructions and that the judge has read to you. And I want to highlight a couple of things. It's negligence, not just regular negligence, but gross and flagrant. A course of conduct showing reckless disregard for human life or the safety of persons exposed to its dangerous effects. And I bolded and underlined and italicized "or," because it's any of those. If you believe the state has proved any of those, then element 2 is proven beyond a reasonable doubt. Or an entire want of care to raise a presumption of conscious indifference to consequences. Wantonness or recklessness. Gross disregard for the safety and welfare of the public. Indifference to the rights of others. So, this is the evidence that you all heard that establishes the defendant's conduct. And it started from the very moment that this whole thing began. It didn't just start when he decided to discharge the taser. Because as I said a moment ago, or pointed out, because the law says it's a course of conduct, or can be a course of conduct. And I would acknowledge to you that it is possible that just one of his decisions may not be culpable negligence. It's the combined effect of everything he did that day to bring about the injuries and the danger to the public. Because even though we have to prove the injury to Jean Baretto-Baerga, I want to make it clear that culpable negligence is endangering the public. This is not about one man. It's about the danger that he created to everyone who was there that afternoon. So, failure to confirm the suspect's identity. It should be clear now from Detective Ruiz's testimony and rebuttal that there was, to put it mildly, mass confusion about who had a firearm that day. Multiple motorcycles of the same color, different descriptions of the suspect from different people. No one at the Osceola County Sheriff's Office, according to the evidence, did anything to clarify that before they went and tried to arrest Jean Baretto-Baerga. He's responsible because he's the one that took the action that led to it. I can't tell you what Benjamin McLean or Christopher Kafinas would have done if they were the first ones there. What we know is that David Crawford was the first one there. And he never once got on the radio and said, "Is this the right guy?" It's that simple. Black half helmet that looks nothing like the helmet that's in evidence that you've seen. It's a different color and an altogether different size. She told you no one put out a description, no one, that matched Jean Baretto-Baerga as the person with the gun. Now the defendant's response to this, or his counsel, will be they don't have to know for sure. Law enforcement can make contact, and it's too burdensome to make them know for sure. The state of Florida completely agrees. They do not have to know for sure. If they had to know for sure, it would place an undue burden on law enforcement that would prevent them from keeping everybody safe. But they can't wholeheartedly guess. Somewhere between wholeheartedly guessing and knowing for sure, there's this reasonable place. Because what you're going to hear over and over again is reasonableness. Is it reasonable, given all of the confusion that was going on about who had a firearm, for this defendant or anyone to not ask the question? And I would submit to you that it is not. And because no one asked the question, they decided to approach, and when I say they, I mean him, the defendant, decided to approach the suspect in a certain way, based from the very beginning on what's at best is a misunderstanding caused by his failure to ask the question. The very last radio traffic, and again, Detective Ruiz told you all that the radio traffic is an hour in length. It is in evidence. You should feel free to listen to every second of it. My representation to you, just as Detective Ruiz's representation to you, was that the very last time that the description of the suspect was discussed, what was said was, "This is not the ag assault. All we have is a fleeing." While I will not play the Now, that's important because the defendant got on the stand and told you that he heard Deputy Kafinas say 53 ag assault, right? That was his testimony. And that, in fact, let me back up a moment. On direct examination, the defendant was asked questions for 2+ hours. There was detailed testimony about his training, about all of his actions that day, about how he got involved, about what parts of the radio that he relied upon, and he was crystal clear that he relied upon the radio traffic and that he had to rely on the radio traffic. No mention of a canine, walking the dog, or not hearing everything. He sits, Detective Ruiz testifies, and it becomes clear that there's a problem, that it is not on the radio. And then he gets it, well, I just didn't hear it all. And I would submit to you that that makes that portion of his testimony completely not credible. But even if you accept a portion of it, even if you believe that that was not the intent, what he said during his testimony was that he missed the first part, and then he heard 53, ag assault. The only brief reference to 53 happens minutes before this, which means that if he was listening to the radio carefully, making sure he was prepared to go to this incident, he would have heard what you just heard. Clearly indicating that this was not the suspect with the firearm. But he didn't do that. And that was the first thing that he didn't do that constitutes his course of conduct. Is that our aggravated assault suspect, or is that just a signal 29? That is the radio traffic, and there's the response. We're not sure, but I have charges for fleeing. That's all I've got right now. Law enforcement doesn't have to be perfect, but they have to be reasonable. And because he wasn't listening carefully enough, a man was set on fire. The next course of conduct that he undertook was his approach to the victim. This is a snippet from the video, and if you recall, he emerges from down here on the video, and you see him walk, not run, walk, all the way up to the pillar on this side so he can watch. And as I pointed out in direct examination, in clear view, all of these bystanders, including a family with kids in the back. Just before, or right around the same time he emerges on this corner, you see one of the children run from this place. He either wasn't careful enough to look at it, or he was completely indifferent to it. There is no other way to describe what occurred. A reasonable person in that moment would say, this is a dangerous situation. I need to be careful. If your truly first command is to protect the safety of the public, that is the first thing that enters your mind. But I would hearken you back to the defendant's direct examination. When his own attorney asked him, what was the ultimate goal? What did he say? To make the arrest. It wasn't anything about protecting the public. His first answer, my goal was to make the arrest. And that is not what law enforcement, according to the training you heard about, is supposed to do. They're supposed to make sure that the protection of the public is paramount in every decision they make. And if that means letting the victim drive away and following the helicopter, that's what it means. And if that means waiting for the other officers to be in position to ensure the safety of the other people at the gas station, that's what it means. He did none of that. I also want to address another concept that's come up over and over again, that this situation was chaotic and he didn't have time to think. All evidence to the contrary. This defendant had plenty of time. You watched it with your own eyes. As he's walking up, hey, where are you? I'm approaching the suspect. Gets on the radio, that's all he's got to do. You guys go around the front, circle him in, make sure he can't escape that way. Deputy Kafinas, you're in your vehicle, pull up right now. I'll go hands on. You prepare to threaten him with a taser. That is law enforcement training. But even if it's not, you know that as common people. Any common person can listen to this situation and say, with multiple deputies within seconds nearby, there is no need for one man to run like a cowboy and tackle someone off a motorcycle filling up with gas. The end result of this was foreseeable from the moment he walked across that parking lot. And it never needed to happen. It happened because he was reckless and indifferent to the safety of others. He was reckless in not listening to the radio traffic, and then he was reckless in his approach. He was reckless in his tackling of the victim off the bike. Because what's interesting is the first time we hear about de-escalation using threats is after it already started. Common sense dictates that you use de-escalation before things escalate. There is absolutely no reason, because the explanation from the defendant was, I didn't want him to know I was there. Okay, understand. So you sneak up or run up behind the suspect, he pulls his taser, which according to the training and his own testimony he can do, and you say, get off the bike or I'm going to tase you. Show me your hands. You give loud verbal commands. At the same time, Kafinas is coming in. He didn't do that. He didn't do any of that. He just pushed him off the bike. He just pushed him off the bike. There was no chaos at this gas station until he arrived. There's evidence that he was reckless because there were innocent people nearby. Like Detective Ruiz, I'm not an expert in distance, but it's easy to see how close that father and son were to where this explosion occurred. Completely foreseeable. And again, he either was not careful in looking to protect the public and looking to see who was around, or he was indifferent to it. And either way, it's reckless and careless. It's culpable negligence. So now, we've talked about the approach, and we'll talk about the taser. There was never a need for the taser to be deployed at all. The evidence on video and from all the testimony was that there were a minimum of 3 deputies going hands-on. The defendant is on the feet, the 2 deputies are on each arm. There was no reason for the defendant not to pull out his handcuffs as they're pulling the arms out and handcuff him. There's no reason not to, particularly given the circumstances in the gas station. I would submit to you that the evidence of the defendant's culpable negligence in this case is overwhelming from multiple sources and well beyond a reasonable doubt. And that the evidence has made it clear that the defendant's actions not only resulted in one man suffering serious injury, but the potential injury, the risk to public safety for many, many more. So we believe we have presented evidence beyond a reasonable doubt that he's guilty of culpable negligence. Now, I mentioned to you that, well, the judge actually mentioned to you that I will speak, the defense will speak, and then I will have an opportunity to rebut. So in a moment, I'm going to have a seat, and defense counsel will be able to make their arguments to you. And while I'm going to save most of my argument and rebuttal for that, I do want to mention something relatively quickly. And that is the claimed legal defense that is in your instructions. David Crawford says he was justified. That's what the justifiable use of law enforcement force instruction that you have addresses. They're essentially going to argue that the law permits what he did in this circumstance because he was making an arrest. But as I alluded to a few moments ago, that ability and right has limits. Reasonably believes necessary to defend himself or another from bodily harm while making the arrest. Reasonably believes. Law enforcement cannot just go headlong and use any force that they wish, which makes sense. They have to use an amount of force and do it in a manner that is reasonable under the circumstances. So their claim to you is going to be that his actions in making the arrest were reasonable. And that is the law. So, as defense counsel was arguing to you, I would ask you to consider and think about what were the circumstances confronting the defendant at the time he was making the arrest that represented imminent danger, that he needed to use the force that he did. How was Jean Baretto-Baerga sitting on his bike, pumping gas, head down, a threat to anyone at the gas station that needed to be dealt with in the manner in which it was? Is it reasonable to discharge a taser surrounded by gasoline? The other thing I'd like you to consider before I sit down is the definition of reasonable doubt. And rather than put it on the screen, I'll just tell you it is the 1, 2, 3. Fifth page. And it's the big paragraph in the middle. And it says, proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. And such a doubt should not lead you to return a verdict of not guilty. Because I asked you to listen during defense counsel's argument for some key words. Possibly, could, maybe, might. Those will be your invitations to speculate about the evidence. And those, according to the law, are not reasonable doubts. Listen for those words, and then after defense counsel addresses you, I will speak to you again. Thank you.
Thank you, Mr. Williams.
Can we take a brief break just before I go? Just a couple minutes.
We'll take a 10-minute recess, ladies and gentlemen. We will be in recess until 10. The deputies will be back to the Thank you.
Jury's exiting.
We can go ahead and bring the jury back in.
Jury stand break.
Mr. Barber, you may proceed.
Ladies and gentlemen of the jury, I just want to say how much we appreciate you giving us your time and your attention throughout this week. I know it's been a long week. I could tell you guys were all paying attention, taking your job very seriously, paying close attention to the evidence. Because of that, I'm not going to go through and re-show every video, every photo. You've already seen it. I don't want to waste anyone's time. I want you to rely on your memory and what you've seen about the evidence. I want you to remember all of the evidence, because that's what we're here for today, is to look at the totality of the circumstances. The state keeps trying to get you to hyper-focus on a few cherry-picked facts, hyper-focus on only half of the law. We are asking you to do what you're supposed to do, which is to look at all of the evidence and look at all of the law. Do you remember back during opening statements? I know it was a long time ago, back on Monday, a lot has happened since then. And what did the state say? They said they were going to prove beyond a reasonable doubt that my client intentionally and recklessly discharged a taser. Now, I'm sure you've all been sitting there all week wondering, when are we going to hear evidence he intentionally discharged a taser? Surely that witness is coming. Surely that piece of evidence is coming. But it never did it? Every single witness who took that witness stand was asked about that. Every eyewitness, the investigators, the experts, all of them. Not one person said that my client intentionally discharged a taser. Not the eyewitnesses who were there. None of them saw it. Not the investigators who reviewed all the video evidence. We asked them, Detective Ruiz, we asked the experts, did you see any evidence of that? No, they can't. Not one person said that happened. Not one person. Not even the Axon engineer, which we will be covering extensively later. Even he said, I can't tell you if a taser is discharged intentionally or accidentally. There's no way to tell. The data doesn't show that. The videos don't show that. We have no way of knowing. The state told you they were going to prove that beyond a reasonable doubt and did not put on even a single piece of evidence. There's nothing for me to argue against. Oh, don't believe that piece of evidence. You never saw it. It never happened. To the contrary, every single witness, every single video conclusively shows you that he never intentionally discharged the taser. You've heard from many, many witnesses throughout this whole case, seen a lot of evidence. The state is trying to convince you that my client committed a criminal act when he absolutely didn't. What the evidence has established is that he did exactly what he was supposed to do. He followed his training. There is not one witness who took that stand who said that he did anything outside his training. Do you remember? I asked every single witness, my witnesses, their witnesses, even their detective. Yeah, you are trained to take down people like that. Yeah, you are trained to use verbal commands of threatening a taser to gain compliance. Yes, you are trained that when there's a suspect who's fleeing from police, that you need to presume that they're dangerous. Yes, you are to presume that that person will flee again. Everything he did was within his training. Yes, we do have to rely on what other law enforcement officers tell us. When they direct you to a suspect, you have to go arrest that person. It's not discretionary. They told you it's their job. They told you that they could get in trouble for not doing that. They absolutely have to arrest people other law enforcement officers have identified. The state keeps going on and on about the fact that, well, he didn't personally confirm the identification, whether he matched every article of clothing and the color that was told over the radio. Yeah, because he doesn't have to. Because you know what happened? As he testified, as every other deputy testified, that person, Baretto-Baerga, the suspect, was followed on camera. You saw at the very beginning, right? He's fleeing from the cops and they followed him all the way to the Wawa. They knew he had fled from police. They didn't suspect it. They didn't think maybe. Detective Ruiz herself, the lead investigator on her rebuttal, said there was no doubt that he was the suspect who fled from police. She even said there was overwhelming conclusive evidence of it because they had the whole thing on video. What else did Detective Ruiz tell you about that? Oh yeah, there's no difference between how law enforcement officers train to respond to an aggravated assault and how law enforcement officers train to respond to fleeing and eluding. Do you remember her saying that? It's some of the last testimony that you guys heard. So all of this argument from the state about, well, he should have matched up the physical description and they can't conclusively show that he did the aggravated assault. They thought he did, but they weren't sure. Is irrelevant. Detective Ruiz told you it was irrelevant. She said that law enforcement officers are trained to respond the same way either way. You know what that means? That means all that evidence does nothing to help you determine this case. Our position is he was reasonably suspected of the aggravated assault. I asked law enforcement officer after law enforcement officer after law enforcement officer about that. Did you know 100% he committed aggravated assault? No, of course not. Did you have reasonable suspicion he did? Yeah, we had reasonable suspicion. We reasonably believed it based on other officers telling us that he matched the description that was given to us. What is the standard to pull someone over, to detain them, to investigate a crime? Every one of them told you it's reasonable suspicion. Every one of them told you there was reason and there was cause to detain that person for the aggravated assault. But then all those same witnesses, including the state's own lead investigator, Detective Ruiz, said, yeah, we definitely knew he was the guy who was fleeing. And Detective Ruiz told you they're both felonies. They're both the same level felonies. And they're taught to respond to him the exact same way. Ladies and gentlemen of the jury, you were to look at the evidence and the law in this case and nothing else. I want to remind you that what attorneys say, what the state argues, is not evidence. You need to rely on your own memory of the evidence and your own common sense when determining this case. And what the evidence shows is that my client acted completely reasonably, he acted in line with his training, and he did what every other deputy testified said they would have done, that they were trained to respond the same way. The state has not put on a single witness who's gotten up there and said, we're not trained to do that. What he did was outside of our training. What he did is not reasonable. What he did is not common police practice. They told you the exact opposite. How many witnesses got there and told you, this is how we take suspects who flee from us into custody. We grab them, we get them to the ground. We are trained to presume they are dangerous. We are trained to presume they will flee again. Now the state said he violated his duty. He wasn't doing his job because he wasn't trying to keep everyone at the Wawa safe. That he wasn't protecting and serving. He was protecting and serving. He was protecting all those countless motorists who were on the roadways, who were put in danger by that suspect, Baretto-Baerga's dangerous, reckless actions of fleeing from the police, driving all over the roads, and putting everyone else in danger. And every single law enforcement officer testified, the state's witnesses, my witnesses, all told you that they believed he would flee again if given the chance. Why did they believe that? Well, many reasons. One, they're trained to believe that. Two, they told you based on their experience. Several of them said the best predictor of future conduct is by looking at someone's past conduct, specifically their recent past conduct. What was that guy doing right when he was getting to the Wawa? He was fleeing from the police. He was still actively engaged in that. Every one of them told you he was a fleeing felon. Every one of them told you that they are lawfully allowed to pursue fleeing felons across county lines. That's why they were there. Now, we heard over and over from the state, he acted unreasonably. What he should have done is gone up there and used his words. Hey, sir, can I talk to you real quick? Can I get you in handcuffs, please? Give me your gun, please. That's the state. That's their argument. Not one witness told you that. Not one of them. Every single person who was asked about that said, no, you can't do that in this situation. You need to approach stealthily. You absolutely can't let them know that you are coming. Why? Because that puts us all in danger. We just knew that this guy was fleeing. If we alert him to our presence, he's going to flee again. That wasn't just my client. Multiple police officers, sheriff's deputies, got up there and told you that. That is why they approached stealthily. That is what they are trained to do. That is what was reasonable in that situation, but to protect the public from that guy taking off on his bike the same way he had just done leading up to that point. He was protecting the public. He had no choice but to take him down. How many law enforcement officers said, that is our job? Somebody has to be first. The state keeps saying, well, he didn't have to go in alone. But that's not what happened, was it? How many videos do you need to see? How many witnesses do you need to hear to say Kofinas was literally a second behind him? You saw that. Crawford, Kofinas, boom, boom, 1-2 punch. I mean, how well does he have to time it to where it's down to the millisecond they're touching him at the same time? Is that reasonable? That's not reasonable. That's almost impossible to pull off in the field, in the real world. I mean, we could slow down videos to the millisecond. We don't live our lives in slow-mo in the millisecond. Things move quick. And when another deputy gets there within a second of you, that is going in at the same time. Use your common sense. I mean, down to the millisecond, they have to grab at the exact same time. That is not reasonable. That is not the standard. He did wait. He did use reasonable care. He came to the Wawa. He stood behind the pillar until he saw his backup coming. And the second he saw Deputy Kofinas, then he moved in because he was doing his job. Because he was told by the helicopter unit, that is the guy you need to arrest. They didn't say, oh, well, here's all these different descriptions. Let's sit here and spend 10 minutes analyzing and going over all the different colors, whether it could be him. That's not how it works in the field. That's not how it works. Every single witness testified, including the lead detective, Detective Ruiz, who filed these charges. Yes, as law enforcement officers, we are required, we must be able to rely on our colleagues identifying and directing us to other suspects. If the helicopter unit is telling them, go get that guy at that pump, by my client, maybe some of the other deputies were negligent in not confirming the identifications. But once they have directed my client to that suspect, my client is not only reasonable in arresting him, he must, according to what you heard from the witnesses, that is his job. They don't have discretion. One officer says, that's my suspect, help me arrest him. They are not allowed to say, no, I don't believe you. I got to do my own investigation. Remember us asking about that? How unreasonable would it be? What kind of society would we live in if a law enforcement officer could not make an arrest unless he personally conducted the entire investigation or he personally observed the criminal conduct. I would tell you, our jails would be pretty empty right about now, because every witness, including Detective Ruiz, told you it is common police practice. It is necessary for them to be able to rely on information given to them by their colleagues in order to do their job. That's a suspect. Okay, they have to trust that person and they have to arrest that person. Not one witness has told you anything different from that. I've asked all of them about it, I believe. I mean, how many witnesses have to say that? The state can argue all they want, but it's not evidence. The evidence shows what they're saying is not true, and that what the witnesses are saying is that my client was 100% it was reasonable, and he was allowed, and it was his duty to rely on that information in going up and making that arrest. Now, I want to start going through some of the witnesses, some of the evidence. Now, the state got up there, and was one of the first things they told you. Baretto-Baerga, the victim, his life has changed forever. Who told you that? Did you hear that from anyone? Did he tell you that? No, he did not, because he wasn't here to testify. That is a fact, not you.
Hold on.
Albert,
It's the same.
May we approach?
sure instruction.
May we approach?
Ladies and gentlemen of the jury, I want to instruct you that you are not to consider the absence of Mr. Jean Baretto-Baerga as a witness in this case in your deliberations. Thank you.
Thank you. The state told you his life was changed forever, but you didn't hear evidence of that. That is what we as lawyers call facts, not an evidence. And remember what the judge told you. You are to make decisions based on the evidence alone that was omitted. And you heard nothing about that. That was purely argument. Now, going back to Baretto-Baerga, there was a very unfortunate fire that day. And it is unfortunate people got burned. Baretto-Baerga got burned. Client got burned. Some other deputies' shoes got on fire a little bit. And the state is trying to convince you that is all due to my client's actions. He's the one responsible for that. Looking at the course of conduct. Well, let's look at some courses of conduct and who's really responsible. Baretto-Baerga, when he was being pulled over by Deputy Kafinas, fled from the police. That was his decision, nobody else's. My client surely isn't responsible for his decision to flee from the police. He fled, and he continued to flee, and he fled all the way across county lines to the Wawa gas station. That was his choice and nobody else's. That is the precipitating fact that set off the entire chain of events. And where do we draw that back to? Baretto-Baerga, not my client. What was my client doing when that chain of events was started? He was with his dog. That's the testimony we heard. How is him being with his dog forcing Baretto-Baerga to flee from the police? It's not. Two completely different decisions being made at that time. Baretto-Baerga fled from the police. Okay, well then he arrives at the Wawa. Let's continue on his course of conduct. The police tried to arrest him. He knew why they were trying to arrest him because he knew they were following him. He knew he ran from the police. You saw in the video, he ran from the police. And the helicopter was following him. And we counted not 1, 2, 3, but 4 times. He looks up directly at the helicopters. And at least once, even gestures towards them. He knew he was fleeing from the police. Do you really believe he was surprised when the police showed up to arrest him after he ran from a traffic stop and the helicopter followed him for all that time? Of course not. Why was he there under the overhang? The same reason he was there under the overhang at the BP. Wasn't he gassed? He was hiding from a police helicopter. He was looking for areas where he could get underneath cover, hoping they wouldn't see him, because he knew they were up there because he looked at them 4 different times. So when my client goes up and grabs him and tries to arrest him, there's no reasonable inference to be drawn that he was surprised. Well, I don't know what's going on. I don't know these are police officers. Of course he did. They've been following him for 20 plus minutes. He knew they were following him. He knew they were there to arrest him. So what did he do? How did he respond when the police tried to arrest him? When he knew it was the police trying to arrest him? He resisted. He struggled. He fought. Those are different words used by different witnesses to describe his conduct. That was not my client's decision. My client would have preferred to have grabbed the suspect, and then he gives him his hands, and then he puts him in handcuffs. That's how police arrest people safely. But sometimes people struggle. Sometimes they fight against the police. And that was Baretto-Baerga's decision. That was his course of conduct. Him alone. That's what put people at risk. Because if when my client grabbed him and said, give me your hands, he said, okay, man, chill, here's my hands, put the handcuffs on. Then what happens? Well, then they stand up and they walk away and they get in the police car. And there's no fire. And there's no struggle. And there's no tasers. And none of that happens. Because we heard from Deputy Cafinas, you use your taser, right? Yeah. How many times? I don't know, in the teens. Well, when? Well, only when people resist or are running. So Baretto-Baerga was not fleeing from the police. He wasn't running from them. If Baretto-Baerga wasn't resisting, there'd be no reason for a taser to even be introduced in that situation. Which, once again, my client never introduced. Because remember, the state said Deputy Crawford drew his taser. Once again, that is not the facts that you heard. He did not draw his taser, or any taser. His taser was secured in his holster the entire time of the entire incident. He picked up a taser, Deputy Cafinas' taser. Every single law enforcement officer testified told you that based on their training, they are taught in the academy and by their agencies that they are to presume that that suspect is dangerous. And now I can break that down into 2 different categories. Let's look at the aggravated assault. I know the state keeps trying to say they didn't have reasonable suspicion of that, despite the fact that every single law enforcement officer, including their lead detective, Detective Ruiz, said they did have reasonable suspicion, and that reasonable suspicion is the standard they use to detain people. And I asked, by detaining people, you could put them in handcuffs to question them and investigate a crime. Yes, that is what their detective told you. I asked, well, is it necessary for you to know 100% that somebody committed a crime for sure before you can detain them to investigate? No, of course not. That's a ridiculous assertion. But I had to ask the question because that's the argument being made. They didn't know for sure, so they had no reason to stop them or detain them. That's not what the evidence shows. Not one law enforcement officer told you that, not even Detective Ruiz. She said, yes, reasonable suspicion of aggravated assault. They had it. Yeah, he was directed right toward that person. Yeah, after that, he has to arrest that person. Where's the unreasonable conduct? Detective Ruiz said that that was his job, that he had to once reasonable suspicion was developed, and he had no choice. What is unreasonable about doing everything you were trained to do? What is unreasonable about doing it the same way that every other law enforcement officer you've heard from had said they would have done it? Nothing. Absolutely nothing. Now remember, the state wants you to focus on facts that were learned after the incident, as if these people are somehow have psychic powers and they can tell the future. That is not what we're here for. Every officer, including Detective Ruiz, told you you have to look at the information known to the officers at the time. You have to look at the information known to my client at the time. She told you, many of these witnesses told you, it is irrelevant if a gun wasn't found later. How does that help you determine what to do in the time when you are told that this person is possibly armed with a firearm? One of the deputies, Mobley, the most senior and experienced of all of them, even told you, I assume everyone's armed until proven otherwise. No one else said that, but at least one deputy thinks that's reasonable, and that's not even what happened here. My client and all the deputies were told, hey, reasonable suspicion of aggravated assault. Let's look at the word reasonable. If there's reasonable suspicion he pulled a gun on people, how is it not reasonable for them to believe he has a gun? At the time, it was reasonable. We cannot Monday morning quarterback this. Shoulda, woulda, coulda. We have to look at what they knew right then and there, and nothing else. Let's talk about Detective Kofinas now. State referred to my client as a cowboy earlier. Remember Detective Kofinas' testimony? I was a Taser instructor in Texas. I have received additional Taser training than the average deputy. He has more Taser training that he received from the manufacturer, Axon, because remember, he's the trainer. What did the Axon expert tell you, their engineer? He told you that we provide the materials. We bring in groups of trainers who then go back and train everyone else. What did Kofinas tell you? He was one of those trainers. He was trained directly by Axon. He told you he was trained not to use tasers around gas pumps. He told you that when he ran up, the first thing he did was immediately draw his taser and shoot it. Kofinas, the cowboy from Texas, running up, quick draw, boom. Doesn't wait for anything else. He's the one who took no time to assess the situation. State keeps saying my client didn't, but that's not true. I'm not going to play the video for you over and over. You've seen it. I don't even know how many times. You know that he goes up and he waits behind the pillar until his backup arrives, and he is assessing the situation. Once the backup comes, he moves in. Who didn't do that? Kofinas. You can watch the videos. You've seen it. You even heard him admit that. Immediately when I ran up, I immediately drew my taser and fired it. Is that against your training? Yes. You didn't really want to. I know you guys had a hard time hearing him. I'm sure you all heard that. So that was against your training? Yes. Okay. You're the taser instructor. You're the one who's supposed to know this. You're the one who has the ability to teach other people. And you run up and discharge your taser? So looking back, right, at the law we're looking at courses of conduct, right? We already went through Baretto-Baerga and how his course of conduct led to this, not my client. Is it my client's fault that Kofinas decided to run up and immediately abandon all of his training and draw his taser and start discharging it at a gas pump? No, that's not his fault. That was Deputy Kofinas' decision. That was his course of conduct. That is how he decided to start the encounter. My client never drew a taser. He never introduced a taser in that situation. Deputy Kofinas did. He immediately draws and shoots him. And then what did he say he did next? Well, then I tase him a second time. He goes in and uses the dry stun technique and hits him again. And by the way, Do you remember the testimony? My client is holding on to the suspect, trying to gain compliance. When Deputy Kofinas discharges his taser into that suspect, my client also got electrocuted with him. He is not the only one, Baretto is not the only one who was tased by Deputy Kofinas. He may have gotten the impact of the punctures, but my client shared in that electrical charge with him, and it was affecting him and locking up his arm. That was Kofinas. Then he comes in and uses the drive stun technique. Once again, are you allowed to use your drive stun technique at a gas pump? No. Is that against your training? Yes. Okay. Once again, Kofinas' course of conduct, not my client. He had nothing to do with Deputy Kofinas' decisions that day. His continuous course of conduct. What did he do next? He takes a taser, an armed taser with the safety off, and he places it right down on the ground next to the right arm of a resisting suspect, a fleeing felon, somebody they are all there trying to apprehend, who every single witness told you was fighting and resisting and struggling the entire time. He never once stopped up until the time the fire ignited. And Deputy Kofinas, against all his training, put that taser down within easy reach of him. He was not the only one who told you that's against training. I asked every single law enforcement officer, do you receive training on maintaining control of your weapons during a struggle with a suspect? Did you hear a single one of them say no? Every one of them said yes. I mean, that's basic 101 policing. Don't let the guy you're trying to arrest get your weapon. That is dangerous. It is imperative that they keep control of their weapons in your hand or holstered. Not, oh, this guy's fighting with me. You know, let's make it a little more lively. Let's give him a better chance. Here's a weapon. You don't do that. Nobody does that. That is unreasonable. That is reckless. That is a flagrant disregard for the safety of others, for the safety of his colleagues, like Deputy Crawford, who's been fighting with this guy, who's sitting there sharing in the electrical current with this guy, who's sitting in the same gasoline that this guy. He is sharing every single risk with that suspect. And it was Deputy Kofinas who put both of them in danger. It was his actions that directly led to a fire starting. His actions that put that taser into that situation. Because remember, where was my client's taser the entire time? Secured in his holster. Why? Because of his training. Because it would have been dangerous to draw. Because he knew that. Because they all knew that. My client admitted over and over, yeah, I knew gasoline's dangerous and tasers can't be used around him. That's why he didn't. But Kofinas did. The instructor. And despite all that, what did we hear Detective Ruiz say? She said despite all those actions of Deputy Kofinas, she didn't send in any charges against him. Only Deputy Crawford. And what did Kofinas tell you about all that? Even he didn't think that was fair. That only Deputy Crawford got charged. Now let's compare Deputy Kofinas a little bit. Let's compare the evidence you've heard so far to my client, Deputy David Crawford. He was doing his job. My client did state his primary goal was to effectuate arrest. The state keeps saying, well, no, that's not true. His primary job is to protect and serve. Once again, cherry picking it. Because what did my client say after that? I asked him, well, why did you want to effectuate the arrest? To keep the public safe. I can't let this guy flee again and get back all down the road and put all those people in danger. He was driving recklessly. It puts people's lives in danger. People flee from the police. It can cause accidents. It can cause fatalities. Why did they think he would flee again? Because he just did. Any reasonable person would think he's going to do it again if given the chance. Hey, I want to pull you over. Nope, I'm fleeing. 20 minutes later, hey, sir, can can I get you in some handcuffs? Will you comply with my orders? You know what? I changed my mind. I'm a completely different person I was 20 minutes ago. I'm no longer the kind of guy who flees from the police. That's ridiculous. Of course he would have fled again. Every single person told her they're trying to believe that. He was protecting the public from that dangerous individual. And guess what? He was sitting on his motorcycle. This keeps bringing that up over and over, trying to make it look like my client was less reasonable. I'm sorry, but if somebody's going to flee from the police, don't you think the fact they're already sitting on their motorcycle makes it so it is much easier for them to immediately take off? If my client announced his presence, he doesn't have to get on his bike and turn on and kick the kickstand, take off. He's there. Just boom, he's gone. Motorcycles are fast. You saw how fast they could go with your own eyes. Much faster than my client can run. My client talked to you about the training he received. And it was no different than what any other law enforcement officer testified. I went to the academy. I learned about I learned firearms. I learned tasers. I developed muscle memory. I learned about takedown tactics. I learned about standards of how I should approach different sorts of suspects. And that's not just him. He went to the same accredited academies that any law enforcement officer has to go to in this state. We heard testimony about that. When it comes to his taser training, he went to the taser trainings put on by Axon. He'd gone to multiple of them, he had said. He went to one the month before this incident. He had been to others before that. He had stated that wasn't his first one. And think back to what every single witness you heard from say. Did you hear a single witness say that what he did was outside of training or policies? Of course not. In fact, it was the opposite. I've asked every law enforcement officer about this. Every single one stated, we are trained in that specific situation Deputy Crawford found himself in. I won't go over all the facts again. You know him. In that situation, he is trained to presume he is armed, he is dangerous, he will flee again. He is trained to grab him and take him to the ground and try to get him into cuffs. Every other deputy said that's how we're trained too. It's exactly what we're all taught to do. So how is he breaching any duty to anyone? How is he not following his training? How is he being reckless if he's following his training? When law enforcement officers don't follow policy, when they don't follow training and people get hurt, that's when they're supposed to get prosecuted.
Objection. Statement of law. You can approach it from
Deputy Crawford followed policy. He followed training. Now, one witness told you otherwise. The exact opposite. Every single one of them confirmed that. Not one person said he did anything that they weren't trained to do. Not one person said he did anything that was outside of normal police practice. If he had violated policies, if he had gone outside normal police practice, if he had done those sorts of things, I can understand why we're here, but that's not the situation. That is not what the evidence showed. He did what he was taught. He did what was reasonable. He did what every other police officer said they were trained to do. He did what he thought was reasonably necessary at that moment with the facts known to him at that time to protect the public and make an arrest and do his job. He is allowed to rely on information given to him by his fellow deputies. Not one witness said otherwise, including the states, including their lead investigator. She said it was entirely reasonable for him to arrest that suspect at that time based on the information given to him by his colleagues, based on that helicopter directing him there specifically. How can law enforcement officers do their job if they cannot arrest suspects that another officer points at and says, that's the suspect, go get him? They can't. They have to be able to do that. Now the state keeps going on and on about the radio traffic. Here's the problem. If you can listen to it, sure. It's in codes. That's why I tried so hard to explain some of those to you, because generally only police officers know those codes. Remember what every officer said. 53 ag. 53 means assault. Ag means aggravated. When my client got in his car, that is the first thing he heard. And every single deputy told you it's not just reasonable for him to rely upon that, it is necessary for him to rely upon that. Now, the state keeps trying to bring up where they say, okay, well, is that the suspect? Right? Well, we're not sure. But then what do they say immediately afterwards? But he matches the description. And then I asked all the law enforcement officers about that, right? Okay, well, why weren't you sure? Well, because we haven't had a chance to stop them to investigate. Of course we can't be sure. And then I asked them, whoa. So what you're saying is you don't have to be certain someone commits a crime to stop them? Of course not. Reasonable suspicion is the standard. So when they're saying we're not sure it's him, but he matches the description, what they're really saying is, yeah, we don't know 100% for sure, because he fled from our stop before we could determine that, but we reasonably suspect it's him. He matches the description. That's what my client hears. 53 ag by Kofinas. This is the suspect of aggravated assault. A little while later, was he here? Well, yeah, we're not sure. Can't be positive. Of course they can't. The guy fled before they can investigate. But he matches the description. And what did every officer, including their detective, say? If one officer, one law enforcement officer says that that person matches the description of my suspect in my crime, they have a duty to arrest that person. They don't need to know for sure. That is not the standard. That is not the law. And that would be unworkable in the real world. They would never be able to pull over anyone, ever, for any suspected crime if they had to already know 100% for sure that they committed it beforehand. I mean, maybe if it was like speeding or something and they could see that. But law enforcement officers all the time, they get descriptions of suspects, they locate them, they detain them to investigate. That's what they said. That's what they do. Of course they don't know for sure yet. You don't even have to know for sure to arrest someone. That's not the standard for an arrest. It's really not even the standard for conviction. So where is this coming from that they didn't know for sure? That is not a standard anywhere in the law. There is not one legal standard anywhere that says you have to be 100% sure of anything to take any action. It's whether it was reasonable to believe it at the time based on the information given to you. And it was reasonable for my client and all the other deputies to reasonably believe he was the suspect in aggravated assault. And more than that, they knew. They didn't suspect. They didn't reasonably believe. They knew he had fled from police. Because in that case, they weren't just relying on some civilian calling 911, giving a description. Another deputy, Kofinas, saw it with his own eyes. It's on video. And they follow him all the way to Wawa. Even Ruiz said, Detective Ruiz, there is no doubt that is the guy. Overwhelming evidence. He fled. And once again, it doesn't matter because they are trained to treat a fleeing felon and somebody accused of aggravated assault the exact same way. So all this talk about, well, they didn't completely confirm the description of the aggravated assault is irrelevant. Even Detective Ruiz told you it's irrelevant. So I don't know why we're spending so much time on it, why the state keeps bringing it up. It's irrelevant, guys. Just, you can put it around your head. Because even if you ignore all evidence of the aggravated assault, let's assume for argument's sake that never happened. Those calls never came in. There was no one suspected of pulling a gun on motorists that day. But Deputy Kofinas went to pull him over for any reason ever, right? We don't know. It doesn't matter. It could have just been, oh, your tag's expired. It could be anything. And then that person flees from the traffic stop. Fleeing is a felony. Detective Ruiz told you it is dangerous. It puts people at danger. So therefore, law enforcement treat that individual as a dangerous suspect. And they would approach and detain that person the same way as if they had pulled guns on motorists. So, for argument's sake, it doesn't matter about the aggravated assault. Even though we do know he had reasonable suspicion of that, even if he didn't, it changes nothing about the analysis at all. It's a red herring in that aspect. Now, the state kept asking, or telling you, that my client should have done things differently, right? I already went over that he should have waited, and in reality he did. I'm not going to cover that, but let's talk about some other things. He should have walked up to him, waited for Kofinas, and then they walk up and use their words. Did you hear a single law enforcement officer tell you that that's how they're trained to handle these situations? Did you hear a single one of them tell you that is reasonable? Or did every single one of them tell you, no, you can't do that? That would put all sorts of people at danger. It puts us at danger in case he pulls a gun on us because we reasonably believe he may have one based on the reports. And there is a very likely risk, I would posit to you, an extremely high one, almost guaranteed he's going to flee from the police because he just got done doing that and he's sitting on a motorcycle. It was unreasonable to believe that they could just go up and ask for his cooperation, he would give it. You saw not just the fleeing, but the resisting. Is there any inkling of any doubt in your mind that that's reasonable? Of course not, because every single witness told you it's not, even the state's witnesses. My client, when he came up, the state keeps saying, well, he recklessly knocked a bike over, spilling gas everywhere. Once again, you have to look at the facts known to my client at the time, not all this 20/20 hindsight stuff. At the time, he told you, and you saw on the videos. He didn't come from in front of him where he could have seen the gas tank. He came from behind him and to the right. You could see it on the video. His body is blocking the gas tank. He can't see whether there's a gas cap on or off or anything like that from his angle. My client even told me, the sun was in my eyes a little bit. You could see it, on the video. Clear as day. You have to look at the facts known to him at the time. How was it foreseeable to my client that his actions were going to spill gas everywhere? If you say someone is reckless, right, what you're saying is they knew or should have known of the risks and they did it anyways. How did he know of the risk gas is going to spill everywhere when he can't see the gas cap on? Oh, and by the way, remember what the helicopter told all them? He's at this gas pump getting gas. And then what he said? Okay, he's done there, he moved to another pump. I don't know if that's word for word, but that's pretty much what they told him. You can rely on your own memories. Why is it unreasonable for everyone who heard that to think that he didn't already fill up at the first gas pump? I mean, you saw him on the helicopter video fiddling around and, with the buttons and all. Why is it not reasonable to believe that he was already filled? Why would any of that lead my client to believe that at that time his gas cap was off or he's filling up with gas? It wouldn't. It's not reckless. So what does he do? He does what he's trained to do. He sneaks up behind the guy, runs up behind him, but without alerting him to his presence, because he needs to make sure he won't take off. He needs to make sure he's not going to pull a gun and use on anyone. Every single other law enforcement officer said that's what they're trained to do. And he grabs him and takes him to the ground. The state's trying to say he used an unreasonable amount of force. When a police officer needs to arrest someone, using your hands is the absolute least amount of force they can use. How are you going to arrest someone without using your hands? He didn't pull his gun and shoot him. He didn't draw his taser. He used his hands and his words, which is the lowest amount of force possible for an officer to effectuate an arrest. He grabs him, puts him to the ground, because every officer, including the state's witnesses, told you, yeah, that's what we do for fleeing felons. You got to get him on the ground so that they can't get up and flee. What are you trying to do next? You got to get his hands on his back and get him handcuffed. That's how police arrest people. Except my client couldn't. Could he? Because the suspect resisted. He fought back. He never showed his hands. Where did he keep them? Underneath them in his waistline the whole time. We heard testimony from the deputies. As they would pull his arm out, he'd pull it back in. He was actively resisting them. Even for argument's sake, again, just for argument's sake, right? Let's forget everything about the aggravated assault. Just put it out of your mind for a second. These deputies, every one of them that was asked, told you we are trained in the academy, at our agencies, and field training that the waistband area is where people commonly carry firearms. And that when we are trying to arrest someone and we can't get their hands out away from their waistline, we are trained to assume there's a gun there that they could use against us. So even without the aggravated assault, my client and all the other deputies were reasonable in believing he may have a firearm, and they had to act accordingly because that is the information that they have at that time. That is what that suspect is showing them. That there is some reason I don't want you to get my hands out from my waistband. That is a dangerous situation, and they have every right to try to use physical force, use his hands to gain compliance from that person, to use his words, even threats of violence, even threats of a taser. Why? Because that's what they're trained to do. Nobody's told you otherwise. Talking about the threats a little bit. He didn't just learn that in the academy. Where else did he learn it? The Taser training school. The one he just took the month before. So a month before this incident, Axon trained law enforcement trainers for the Taser, sat him down in a class with Deputy Kafinas. Remember you heard they were even sitting next to each other. They're in the same exact class. And they got a refresher a month before. So all this training they received, it wasn't from years ago. It was fresh in their mind. They just went over again. And what did they learn? They learned that threatening the use of a taser is a valid means of gaining compliance from a resisting suspect. Not just that, though. Verbally threatening it is totally allowed. But even more so, they were told in that training, even threatening them by arcing that taser is even acceptable, which is a much higher show of force than what my client did. All he merely did was tell them, you can get tased again if you don't stop resisting. Once again, not an exact quote, use your own memory, but that is what he's indicating. He's trying to gain compliance from a resisting suspect. Not one deputy took the stand and said, yeah, I mean, we only tell people we're tasing them when we're going to tase them. Every single one of them say, we all do that. Not only is it taught, it is a common police tactic, law enforcement tactic, that's used every day in this country. That's what you heard from the witness stand. This isn't something that he just did. Let me ask you, if it's unreasonable to do that, if it's reckless to do that, then why is it so common that every day in this country, law enforcement officers are doing that? What, they're all reckless? They all are committing crimes? Of course not. They're all stating their intent? Of course not. All those witnesses who were asked told you, we do this too. We do it all the time. It is common. It's appropriate. It is taught. They are trained on it. He used his words, not his taser, his words. Remember sticks and stones? Sticks and stones can break my bones, but words can never hurt me. That's all he used was words. Deputy Crawford never drew a single weapon throughout this entire event. We heard that over and over. His taser was securely holstered. His firearm was securely holstered. Why is that important? Because of the other evidence we heard from multiple law enforcement officers. Even some of them, I think, were trainers. Yes, in the field, if we're in a situation where we have to use our weapon, including a taser, I specified that, and you have to choose between your taser or one that had been discarded on the ground, which are you going to choose? Every one of them said, of course we're going to use the one in our holster. We are trained. You can't rely on that weapon on the ground. You don't know it's functionable. You don't know if there's something wrong with it. You don't know if all the cartridges are spent. We're just going to guess. Hey, I'm just going to do some guesswork and, maybe, 50-50 this thing's going to work. No, they all said you're going to grab your taser that you know is going to work, that is holstered with you. Because if Deputy Crawford was actually intending to tase Baretto-Baerga, he would have drawn his taser. So, now that we know every witness said that is what would have happened, that's the only way they're trained to do it, we have to look at, well, then why did he pick it up? And that is obvious because Deputy Kofinas went against his training and placed an armed taser right next to the right arm of a resisting suspect. A right arm that they did not have control of. A right arm that's attached to a right hand that they did not have in handcuffs that was still underneath them. And it was within easy reach. And every single law enforcement officer you heard from talked about this fact that they are trained that you absolutely cannot allow a resisting suspect or any criminal suspect to gain control of your weapon or have access to it. You have to maintain control. I even asked Deputy Kofinas about that. He said, yes, that's exactly what we're trained to do. So did you violate your training there? Yes, I did. Once again, Deputy Kofinas, not my client. So why did my client grab the taser? Because now that Deputy Kofinas has dangerously left it next to a resisting suspect, he's got to remove it from his grasp. We heard the other deputies say that. Well, what if it is within their reach? Well, then we have to remove it. Have to. They didn't say should. They didn't say you should think about it. They didn't say maybe you should leave it there depending on the circumstances. They all said you have got to remove it from their reach and get it out of there. And that's what my client did. He picked it up with his right hand, he moved it to his left hand, and he threw it to the left. Now, I'm going to break this down and demonstrate a few things for you guys because I think it'll really be helpful, especially given some of the testimony we heard yesterday. I'm going to set up what's called a demonstrative exhibit. Nothing I'm about to show you is in evidence, all right? It's just used to demonstrate. Yeah, may I ask the jury if they're allowed to see this clearly?
They're able to, sure. Can you all see that?
All right, I'm going to move it back a little bit. Is that any better?
I can't see anything. Can we stand
Do we
here?
have permission to stand, Your Honor? Okay, thank you. I'm going to set a few more things up just to let you know. Now, for the purpose of this demonstration, I'm just trying to walk you through and help give you a visual of what actually happened. So, use your imagination a little bit, please. This is the gas pump. You've seen all the videos. You've heard the testimony. The suspect's on the ground, and that's what the clothes are here to represent. Just so you can see where my client was in relation to the suspect. He's wearing jeans. He's wearing a t-shirt. These are not his. These are not in evidence. They're just to demonstrate a point. What do we know? We know immediately to the right, there's a gas pump. What else do we know? It was a very confined space. A couple of feet, I think, is what the witnesses said.
The state has an objection.
Could you all approach, please? Ladies and gentlemen of the jury, I want to remind you all that this is completely a demonstrative aid, and that you are to rely on your own memories and the evidence, your own memories of the evidence, and the testimony as to the area of the scene of the incident. Thank you.
And so once again, this is just to demonstrate. This is not exact. These clothes aren't in evidence. That is not a Camaro. I couldn't get it up here today. This is not a gas pump. Probably not safe to have in a courtroom. I'm going to demonstrate, and I need you to use your imagination a little bit. I can't say, because nobody can say what the exact distance was between the gas pump and the Camaro. You saw the videos. You heard some testimonies in a very confined space. So, to demonstrate, this is Baretto-Baerga. My client, as you saw on the video, was down here by his legs. There was another deputy here. There's another deputy over there trying to get that arm. There's a gas pump here. On the other side of that gas pump, there's a motorcycle and there's gasoline, and it's coming this way. So you got to remember, gas pump, gasoline on the right. On the left, we have a Camaro. This, while not exact, I cannot tell you exactly how much distance there is between the pavement and the bottom of the Camaro. This is just a demonstration. So, you all heard testimony that the state elicited from Deputy Kofinas. They used a video from way far back from the gas pump. where the taser's a little speck. And they asked him, well, look at this, and how far is the taser from that gas pump? Oh, it's about 6 inches at most. Remember that? And then what happened? I got up on redirect and I hit play. And what happened on that video? Cofinus walks up to the taser, and then I paused it again. And I asked him, now that you have a fair angle of this because you're up close and you can see it better, is this 6 inches between the taser and the gas pump? No. What is it more like? He said it was several feet. And I asked him, is that how distance works? The farther away you are, the smaller things look? Exactly, including distances. So let's break that down a little. The state actually tried to convince you through Deputy Cofinus that the taser was 6 inches from the gas pump. So I'm Deputy Cofinus. The taser is set down. I'm going to pick it up right here. Well, how if I transferred it to my left hand and you see on video he's going over here, how could it possibly have been 6 inches from the gas pump? It couldn't. It makes absolutely no sense. So let's demonstrate what did happen. Because when you saw the video, you saw that taser was several feet from the gas pump. So I'm Deputy Cofinus. I'm on the ground. I'm struggling with this suspect. I'm sorry, I'm Deputy Crawford. I'm on the ground. I'm struggling with this suspect. Deputy Cofinus places his taser. And you can rely on your own memory. I have no time to think. I have to act. So I grab the taser. According to the state, I want to tase this suspect. He's right underneath me. Okay, how would that happen? I grab it, I mean, it's right here. That's all he would have done. If my client's intention was to tase this man, if he picks up an armed taser, because remember, Deputy Cofinus left him down the safety off, why would he turn the safety back on if his intention was to tase him? Why wouldn't he just do this? Now, I understand he's left-handed. He shoots with his left hand. He throws with his left hand. So maybe this isn't a fair demonstration. I mean, I'm right-handed. This is easy for me. So let's reverse it real quick. Oh my God, look at that. I can sit here and touch the person directly underneath me who I'm touching, who I'm actually on the ground with, without even thinking about it. I'm not even looking. I'm hitting them every single time. But it doesn't matter which hand it's in. If he wanted to intentionally tase him, that's what you would have seen on video. But you didn't, did you? What you saw is he picked it up, he flipped on the safety, and then he transfers it to his left hand. Why? Because it's his throwing hand. He doesn't, it is a shooting hand. I know the state's saying he transferred his left hand, right? Because he wanted to use it to shoot the taser. You don't shoot a taser at this distance. That's what they told you. When you're this close, you drive stun him. How would it make sense? And even if he did shoot him from this distance, what did we hear from all that testimony? There wasn't a connection. What, at this distance, with his dominant hand and all the training he's been through, he misses? Does that make any sense at all? No, it doesn't. Now, the state went through all this evidence over and over. I mean, how many times did they show you the prongs and show you where prongs had stuck in Baretto-Baerga? Right? How many times? They were up there. Those were Cofinus' prongs. So the state's theory is he moves into this hand to shoot him with it. Has there been any evidence that there were any prongs down here in his legs for Deputy Cofinus? Was there anywhere on his body? Is there any evidence that besides the 2 prongs that Deputy Cofinus stuck in him, there were any more prongs in this suspect? No. Why? Because he didn't shoot the taser at him. If he did, in his dominant hand, right here, how would you miss? And why would he even do that if he could just pick it up and tase him right here with his right hand? It doesn't have to be your dominant hand to do something that simple. What my client's testimony was, and what the evidence shows, the video evidence backs this up, and even the state's witnesses, right, even the Axon engineer, which I'll get back to him, admitted, yeah, that's consistent with your client throwing it under the Camaro. He transfers it into his throwing hand. And remember when I went frame by frame? You see him leaning to the left as his arm extends out and goes like that. Because yesterday, right? Yesterday, when I was making the motions, I kept saying he's throwing it to the left and the pen was flying across the room, right? All right. But now I'm showing you a more accurate example. Because you may have been thinking, well, why wasn't the taser like 10 feet away or across the parking lot? because there was a car there. So yes, I can throw it because there's not a car here, but remember, you're imagining this is a solid Camaro. So when I go, my movement is blocked. I can only get so much momentum and so much extension of arm and so much range of motion. So when I throw it, it doesn't go far. It's going to just skid and land a few feet from the pump, exactly how you saw in that video when we were able to give you an honest view of it right up close after Deputy Kafinas had walked up. Why was it found there? Because that's what happened. Sorry. Oh, yes. I'm done here for a moment. How else do we know that's what really happened? The taser. I'm not going to grab and show it to you again. You guys have seen it over and over. You've heard every witness say it was pristine condition. Pristine. You saw it yourself. There's nothing wrong with that taser. What's it made out of? Plastic. It's made out of rubber. What does plastic and rubber do in gasoline fires? It melts and burns. It puddles. The plastic would puddles, what the arson investigator said. Did you see any of that? No, of course not. No one did. Why? Because the taser was not in my client's hand. So I know I say you could just sit, but I'm sorry. There's one more time. So let's think about the state's theory of defense. I have this taser in my hand, right? There's gasoline everywhere now. I go, I point it down at this suspect beneath me, even though the video never shows him pointing it down, even though everyone who was asked stated he never pointed at the suspect, right? For argument's sake. Listen, he points it down, he discharges, somehow he misses, it causes the fire, boom! I am now engulfed in flames with a taser in my hand that I'm holding because I just discharged it. So now I'm engulfed in flames, and this is the state's theory, if you actually want to believe what they're saying. I am on fire, I am burning, but the taser's not. Magically, this taser has a force field around it? How would it not burn if it's in the same fire? Because it's in his hand, because he intentionally deployed it. That makes absolutely no sense. That goes against all common sense. The arson investigator said, right, the only way that taser would be in this condition, not have the burning or the melting, was because it was removed from the fire before it could be burned. How was it removed? Because it wasn't in my client's hand. What's more likely, if you even believe the taser started the fire, which we're going to get to that next, that there's no evidence of that, or insufficient evidence, there's extreme reasonable doubt the taser started the fire, but even if you believed it did, the only way that makes sense is that it went off as my client was discarding it. That's why it wasn't in the fire. If he was intentionally holding it and discharging it, you would have seen that damage, and you didn't. It is pristine because it wasn't in the fire, because he was throwing it as the fire started. And we admitted that. I asked my client, based on review of the evidence, would you admit that the fire started about the same time you're discarding the taser? He said, yeah, it was about the same time. That doesn't mean proof beyond reasonable doubt. It started it. Sorry, I promise you get a seat now. Now, just to briefly go through some of these other witnesses. Deputy De Jesus, right? We heard from the arson investigator, it is possible that when he went to pick up that bike, the metal scraping the ground could have caused a spark that could ignite gasoline. He said, yeah, that can absolutely ignite gasoline. And what happened? Deputy De Jesus testified, I grabbed the bike, and immediately when I grab the bike and start moving it, the fire erupts. That is reasonable doubt. That is another reasonable hypothesis for how that fire started. When we say reasonable hypothesis, and I'm sorry, that's not me. That's the arson investigator saying that. When he says that, that's another way of saying reasonable doubt. If that's another reasonable hypothesis, then that means right there, there's reasonable doubt as to how this fire started. Deputy Jesus tried to change up his testimony a little bit from what he had said before. Before, as I pointed out, he had said, I grabbed the bike, I immediately saw spark, and then fire. That's what he said. And now he's trying to say, well, what I really meant was, yeah, but that's not what you said. You gave two statements that were different. He eventually admitted, okay, yeah, when I grabbed it, the fire didn't immediately start. And by the way, Deputy Jesus testified he only ever heard one taser discharge. Deputy Kafinas never even heard a second taser discharge. Talk about Detective Ruiz again. Talked about the identification. Oh, he never confirmed it. But remember what I asked her on cross? I'm sorry, detective, but isn't the helicopter unit telling my client, hey, go arrest that specific suspect on that blue and white motorcycle at that gas pump? Isn't that an identification of that suspect as the person he's going to arrest? Yes. So he did follow and confirm the proper identification as given to him by the helicopter unit. And she also said that based on that, what did he have? Reasonable suspicion that he was the aggravated assault suspect.
Objection, this statement is false.
Stop it. Thank you. She had said that gave him reasonable suspicion that that person's aggravated assault suspect, and she had also stated they knew he was a fleeing suspect. Remember, no difference. Even she couldn't testify to a single policy that my client violated. Even she couldn't say he did anything outside his training. And she's the one who filed charges. If she can't even point to anything he did outside training or policy, what are we doing here?
Objection, any objection, is sustained.
Sustained.
Any other question of the prosecutor?
Yes, you can. Ladies and gentlemen, at this time I want to instruct you that the state of Florida does not have to prove that the defendant violated a policy of the Osceola County Sheriff's Office. That is not an element of the crime for which Mr. Crawford is charged.
And I just
Give me a
Thank you. Now, you did hear Detective Ruiz, though. She testified extensively. And understanding what the judge just said, she couldn't point to a single thing my client did that was outside of training or outside of policy. My client relied on his training. He relies on policies when making decisions in the field, like every single law enforcement officer does. Now, when bad things happen and people get hurt, it's natural for people to want to look for someone to place the blame, but that is not the law. This case against my client has to be proven beyond the exclusion of every reasonable doubt, and the state has not done that. Moving on to Detective McClain. Once again, he went through all this training. I'm not going to repeat it, but he had said every single thing my client did was how they were trained, as far as muscle memory, the takedowns, the relying on information given to him by other people, the assumptions that he's armed and dangerous, the assumption he's going to flee. He stated all of that. You heard it all. He also stated that, like my client, he wanted to get there without alerting the suspect to his presence, because he also thought it would be dangerous if he knew that the police were coming and were imminently about to arrest him. Why? Because of the risks of him fleeing again, because of the risks of him pulling a gun and using it on people and a gunfight erupting at the gas station. So this isn't just what my client is doing. This is what all the other deputies also believe. The takedown was proper, he said, and in line with their training. And he admits it was my client who gave everyone the warning about the gas. Why? Because my client told you he was trying to keep everyone safe. He knew about the risks of the gas. He was in the gas. He told you he didn't want to be on fire. He knew that if he discharged a taser while he's on the ground, and as he said, with gasoline soaking into his clothes, that he was going to be lit on fire. The state's theory is that knowing that, he did it anyways. That when you saw my client running across the video on fire, the state's theory is he did that on purpose. That he intentionally discharged a taser in gasoline knowing the flammable nature of it. Does that make any sense to you? No. Because that's not what happened. Because there is reasonable doubt, because this case has not been proven by the state. McClain talked about de-escalation techniques. Once again, completely in line with everything my client said. Verbally threatening the use of the taser is not just common, it's taught, it's allowed, it's proper. Talk about crime scene technician Melendez. Some of the briefer testimony we have, won't spend a lot of time with her, but what did she say? She said her job's to mark where all the evidence is. So that we could know exactly where the taser was, but that she was prevented from doing her job. Why? Because once again, Deputy Kofinas didn't follow his training, and he picked up his own taser and removed it before the people who were supposed to come and mark where it's at, supposed to investigate, had a chance to see it. Once again, Deputy Kofinas' actions. I want to get to the arson investigator, Detective Kameni. Right off the bat, everything else he said, out of all of that, the most important thing is, I can't say whether a taser is discharged on purpose or not. And I believe, my conclusion, is that this fire was set off accidentally. On accident. And he can't say whether the taser was discharged. He did give us some other really good testimony, though. He gave us reasonable doubt as to how the fire even started. I asked him over and over about different theories. Some of them I left alone. Listen, I'm going to concede that Camaro, the hot engine, of course it didn't start it. Why? Because we know the Camaro wasn't hot. You saw pictures under the hood. It's fine. There's no fire damage. We're not arguing that. We never once argued that. So I'm just going to move past it. But I did talk extensively with him about some of these other hypotheses and how they could be much more likely to happen if there were certain factors that you saw. The hot engine from the motorcycle causing the fire. What did he tell us about that? Well, yeah, but I don't think that's what happened. Well, why not? Well, because that bike would have to be very, very hot to ignite those vapors. Well, what do you mean by that? I mean, like, above its normal limits, way above what's normal, to get it hot enough to ignite that vapor. What did we see in the evidence? We put Deputy Mobley up there. What did he show you? He showed you 20-something minutes of video of that person, the suspect, riding that motorcycle at the max of its limits. 9 different wheelies where he's revving it all the way to the red line and pushing that engine to the extreme of its limits. Every time he does that, 9 times. What else did we know from his testimony? The video. Can we tell exactly how hot the bike was? No, because as Detective Kennedy said, he wasn't there at the thermometer to take the temperature. However, we know how hot it is compared to other objects because we have an infrared camera of it. Detective Kennedy, who operates those cameras, trains other people on how to operate them, told you that bike is extremely hot. I mean, it is bright white. I asked him, is it hotter than all the other vehicles in that parking lot? He said, absolutely, much hotter because of the manner in which it was driven, which is the exact factors that Detective Kennedy told you would significantly increase the risk that that bike started that fire. I asked him, is this hypothesis within the realm of reason? He specifically said yes. You know what is another way to say that? There is reasonable doubt as to how this fire started. I'm not telling you that. The arson investigator is telling you that. Those were his words. There is a reasonable hypothesis. Okay, is it just reasonable? Well, no. It'd be much more likely if we have certain factors, and then you saw those factors. That right there creates reasonable doubt as to how this fire started. Not one person has been able to get up there, including the arson investigator, and say, we know the taser started the fire. I even asked them, are you 100% certain? Are you certain the taser caused the fire? No, I'm not. Why? Because there's other reasonable hypotheses. Now the state's going to try to say he ruled all of them out. But guess what? He did not get to see all the evidence you did. He did not get to see the helicopter video and how that bike was ridden. He knows if it was written that way, it would have made it much more likely, but he didn't know at the time that's what happened. That's why he ruled it out. He didn't know that the very factor he was going to say would make this way more likely actually happened. And then you saw the infrared camera. He didn't see that either. He also stated, well, as the state pointed out, I would have expected the fire to start quicker. Do you remember me asking him about that? Doesn't it take time for fuel vapors to concentrate before they ignite? Yes. But there's a difference between whether it's inside or outside. Okay, let's break that down. He was outside. So they wouldn't concentrate as quickly, but he also stated there's no wind, but they're also in a confined space. And I asked him, he said, yes, those are all reasonable factors to look at when determining whether that bike could have started it. And it would take time for them to ignite. I got him to admit that, yeah, not necessarily. Just because I would expect to see that doesn't mean that that's what has to happen. Doesn't mean that's how it happens every time. He admitted that, yeah, that's just what I typically see, but it's not what I always see. Why? Because it is absolutely reasonable to believe that that bike and that hot engine could have started that fire. There is reasonable doubt as to how that fire even started. There's also reasonable doubt that even if the taser did start the fire, that my client ever intentionally deployed it. Because he didn't. There's not reasonable doubt on that. He absolutely did not intentionally deploy the taser. You see no evidence of that. Not one witness has told you that. Not the eyewitnesses, not the experts. I demonstrated for you how that is completely impossible. How the state's theory of the case physically makes no sense because of the condition the taser was in, because of where the taser was found. We talked about stack electricity with the arson investigator. Yes, stack electricity, and what did he say? He said can absolutely ignite fuel vapors. Not maybe, not possibly, absolutely. He was certain about that. And what else did he say? Yeah, we have those warning stickers on every single gas pump in Florida. Everyone's seen them. They specifically warn you to stay off your cell phones because of the risk of static electricity discharging fire. They specifically warn you not to have the engines running when you're fueling them because of the risk of that creating an electrical discharge that can start a fire at a gas pump. Do you really believe all those warnings are on all those gas pumps for no reason? Absolutely not.
Could I have, excuse me, the lawyer's report, please?
Now, I know he tried saying, the arson investigator that is, well, I mean, I haven't specifically seen that. Oh, okay, but you haven't seen every which way fires start, right? Right, and you see new things every year you work as an arson investigator, right? Right. So not seeing it yet is not the same as it doesn't happen. Those warnings are out there for a reason, because it happens. That in and of itself is additional reasonable doubt on how the fire started. And what was his ultimate conclusion? His ultimate conclusion was that the fire was started accidentally. And I specifically asked him if he saw any evidence it was ignited on purpose. And he said no. And that is the arson investigator. He's the person more qualified than any other witness we heard to talk to us about how the fire started. And even he's telling you he doesn't know. He can't tell for sure, but the state wants you to believe you know beyond a reasonable doubt, despite all the evidence we've seen about the bike, despite everything we heard about electrical discharges and static electricity and cell phones and cars? Absolutely not. Now, Brian Childs, let's move on to the Axon engineer. Now, he had a very hard time answering my questions. He did not want to admit that he had previously given statements under oath that were different than what he was trying to tell you today. Another way to say that, he was changing his sworn testimony. Another way to say that, if you have two different stories and only one could be true, then you're lying about one of them.
Objection. Is that use of the word lie?
That is another way to say that. I asked him over and over, sir, you're saying now, today, oh, there's nothing wrong with this taser. It's working just fine, perfectly operational. But that is not what the evidence shows. That is not what he had previously said under oath. I had to pull it out of him. I mean, I had to get in a little bit of a back and forth just to get him to admit what he previously said. And what did he say? He said there was a bug, an anomaly. And not just any bug or an anomaly, a unique one that they had never seen before. He is the senior forensics manager at Axon, and he's never seen it before. Why? Because this particular taser in this particular case has something wrong with it, a bug, an anomaly. And specifically, what is it? This specific taser reports trigger discharges in its data that never happened. He used the word to describe it as a phantom trigger pull. Think of You know what we call it in court when the only evidence you have to prove something happened is not credible or not reliable? We call that reasonable doubt. Just one of the many examples of reasonable doubt that you've heard in this case. We don't even know how the fire started. We don't even know if the taser trigger was ever pulled. The only data you have that was pulled was that, or the only evidence is that unreliable data. You have to ask yourself whether you are willing to find beyond a reasonable doubt that my client committed a crime and intentionally discharged that taser based upon data that admittedly shows trigger pulls that didn't happen. Based upon the presumption that the taser started the fire, even though we know there's reasonable doubt, there are other reasonable hypotheses for how that fire started. And I'm confident that you are not going to feel comfortable doing that and that you are going to find reasonable doubt. We also went through the warnings, the Axon warnings put out by his company. I asked him about it. Sir, what about these warnings that specifically state there's a risk of automatic discharge or self-discharge of these tasers? Just forget about that. We fixed that. That's not for the Taser 7. We fixed that part. They don't go off by themselves anymore. Then why is it in the warnings? Same thing we talked about with the stickers on the gas pump. The warnings are there for a reason. Of course he would want you to believe that their tasers don't go off by themselves. Because if it did, and if that taser went off by itself without someone pulling the trigger and caused that fire, then who would be responsible for that fire? Axon would. They would be responsible. And their product would be responsible. Their flagship product that they sell, that they rely on for their revenue. That is reasonable doubt. Let's move on to some things that he was willing to admit. He admitted he can't say whether a taser is discharged intentionally or accidentally based on the data. Even for argument's sake, if you could rely on that data, which you can't, it doesn't tell you anything about whether a taser was intentionally discharged or not. He freely admitted that. So once again, what evidence do we have that that taser is intentionally discharged? None. None of the experts, none of the eyewitnesses, none of the videos. He also corroborated that yes, if you put that taser in a gasoline fire, it will melt. It will burn. You saw the taser. That didn't happen because it wasn't in the fire. We talked about how much pounds, how much force it takes to pull the trigger. He said it was 2.2 pounds on this specific taser, the extreme bottom end of what they see. You know another way to say that is? That particular taser that they manufactured, that they validated was good enough to put into circulation, that was good enough to issue to a law enforcement officer, right? That specific taser requires less force to pull that trigger than most other tasers. Another way to say that is, it's more likely that that particular trigger can be hit accidentally during a scuffle if somebody's trying to discard a taser, because it requires less force. He also said he never even opened up the taser to look at the circuitry. He's a senior forensics guy. How good of a forensic analysis did he do if he doesn't even open up the device? That'd be like doing an autopsy and not even opening up a body. How are you going to know what happened? We went through the body camera video of my client with him, frame by frame. He admitted that nowhere on that video does my client point that weapon down at the suspect. He kept it pointed straight ahead and at times even up, all the way to the point where you see his arm extend off to the left and he's leaning to the left. Why? And we got him to admit that's consistent with throwing the taser off to the left. He also said, yes, with our product, like all projectile weapons, you aim it at your target. I asked him, if I aim it straight ahead and the target's down here, am I going to hit it? He said no. And that's what you saw in the video. The target was beneath my client, or who the state says his target was, right? And he was pointing it straight ahead. How does that make any sense? It doesn't, because he wasn't intending to tase him. If he was, it would have been a target he was trying to hit. He would have pointed it at him.
Frankly, you wouldn't even need to point it because he's right on the guy. Remember, you just touch him with it. We looked at McLean's body camera video with him. He admits the video shows my client turning the safety on, and it lines up with the data as he does it. So in that particular case, okay, now we've corroborated at least one piece of the data, right? They turned the safety on. He testified to it. The video showed it. The data shows it. At least that one line, the data, I guess, is accurate. But then, what about the rest? What about my client presumably turning off the safety and pulling the trigger? That wasn't on the videos. There's no corroboration. Another way to say that, the only evidence you have of that was the data. The same data that reports actions that never happened. That is reasonable doubt. Can I say for certainty everything exactly what happened? No, no one can. And that's not my job. We understand that there's times where the taser's on the video. But guess what? I don't have to prove anything. The judges told you. The state has the burden of proof. It is their case to prove beyond a reasonable doubt. My job, which I'm doing, is showing you that there's overwhelming reasonable doubt in this case. And to end my discussion, Mr. Childs, remember what he had said. He specifically said he's seen other cases where officers have accidentally deployed tasers without intentionally squeezing the trigger. His testimony. Where's the intent? We haven't seen it anywhere. And he also said you cannot tell from the data whether it's intentional or not. Let's move on to Deputy Sheriff Mobley. I won't repeat everything I've already said. I think we established most of it. He did the 9 wheelies. However, one more important piece of information from him, right, is that this suspect knew he was being followed because he looked up at the helicopter 4 times. He knew it was up there when he was at the Wawa, meaning my client and all the other deputies should reasonably believe that he's going to flee again if he is discovered. He knows they're looking for him because the helicopter's up there. And he also turned out to be a motorcycle instructor. I didn't even know that when I asked him, but he's a motorcycle instructor. He knows everything about motorcycles, and he told you exactly how wheelies are done and how that pushes the engine to the extreme. Now, the state kept talking over and over about my client's field of vision and what he could have saw. What did Deputy Mobley tell us? He told you that in those high, fast-paced, quick-moving situations, that you get tunnel vision. You don't have your full field of vision. And I also established in my client, he only has 2 eyes in the front of his head, just like all of us. He can't see 360 degrees. And he was focused on one suspect because that was his job, was to get that guy in the cuffs to protect the public from him fleeing. Also, he's a firearm and tactics instructor and a former SWAT team member who said it was completely appropriate for my client to take down that suspect the way he did. Not one person has proven that my client did anything reckless, that he ever consciously or intentionally deployed a taser. Not one person had said that him grabbing the suspect the way he did was unreasonable or illegal, because it's not. To the contrary, they all told you it was in line with their training, it was the way they would have done it, and it was completely reasonable. He is a law enforcement officer. He has got to be able to use force to do his job. He has got to be able to arrest people. He has got to be able to use his hands and grab suspects who fled and take them to the ground to get them in handcuffs. Him and any other law enforcement officer cannot do their job if they cannot grab suspects who fled from police to try to get them in handcuffs, and then use techniques to try to gain compliance when they fight against them and resist against them. Just really quick, I want to go through some of the law that your judge has instructed you on. Each of us has a duty, and I'm reading for you the culpable negligence definition. Define culpable negligence. Each of us has a duty to act reasonably toward others. Every single witness, every officer who was asked, stated that what my client did was reasonable based on the information known to him at the time. Culpable negligence is more than a gross failure to use ordinary care. In order for negligence to be culpable, it must be gross and flagrant. That has not been proven in this case. He did what he was supposed to do, what he was trained to do, what every other officer said they would do the same exact way. They have to show a course of conduct showing a reckless disregard for human life. That's not what happened. He told you he was concerned about the safety of the public because this guy was going to flee again, and that's why he had to give him the handcuffs. And that's not just him. Every other deputy backed him up on that. Or they have to show an entire want of care to raise a presumption of conscious indifference to consequences. Do you see any evidence of that he didn't care? No, none at all. It has not been proven. There's been no evidence of that. To the contrary, he told you he was there to protect the public by arresting this fleeing felon. It wasn't reckless. It wasn't grossly careless. And he did not show a disregard for the safety and welfare of the public. To the contrary, what he did at that time, based on all the information known to him then, was for the benefit of the public to protect them from the suspect who was fleeing from police. I'm now bringing your attention 3.6H, justifiable use of law enforcement justifiable use of force by a law enforcement officer. A law enforcement officer or any person is summoned directly to the system need not retreat or stop efforts to make a lawful arrest because of resistance or threatened resistance. What is this saying? When the guy flees from police, he doesn't have to go up and just, hey sir, will you please come with me, like the state suggested. He's allowed to use force because he resisted by fleeing that traffic stop. And then, as he's on the ground with them, the guy continues resisting. The officer is justified in use of any force that he reasonably believes necessary to defend himself or another from bodily harm while making an arrest. Every officer up there told you they were afraid this guy was going to pull a gun because of the reports they got, including my client. They all reasonably believed that. But if you remember what the state put up there, those are the parts he highlighted, except that's not the whole law. Let me draw your attention to number 2. The force is also justifiable when necessarily used in arresting a felon who is fleeing from justice. Has there been any doubt at all that Baretto-Baerga was fleeing from justice? Detective Ruiz told you it's a felony to flee. When he is fleeing, he is a felon fleeing from justice. He is justified in using force to apprehend him. Done. The rest of this, I say we check that off and that's been established. But even if you didn't believe that, there is no doubt he can use force based on number 2. No doubt at all. Now moving on to plead not guilty, reasonable doubt, and burden of proof. Second sentence. This means you must presume or believe the defendant is innocent. You have not deliberated yet. At this exact moment, the only belief you should have in your head is that he is still innocent. That is what this says. And that presumption stays with him as to each material allegation in the information through each stage of trial, unless it has been overcome by the evidence to exclusion of it beyond any reasonable doubt. That is not what happened in this case. Almost every single issue, from how the fire started to whether the taser was ever even had the trigger pulled on it, there's reasonable doubt as to all of that. We don't know how the fire started. Nobody knows, not even the arson investigator. But the state's going to ask you to believe that you know beyond a reasonable doubt, even though the arson investigator doesn't. What about the taser? They want you to find you know beyond every reasonable doubt that that data is reliable and that my client pulled the trigger based solely off that data. When you know that data is not reliable, you know it states there's trigger pulls that don't happen. Why? Because that's reasonable doubt. Nobody knows what happened in this case because the state hasn't proven it. Because there is an immense amount of reasonable doubt as to pretty much every single issue except one. Whether my client acted reasonably, which we all know he did, based on the testimony of every single other law enforcement witness. I'm moving on to weighing the evidence. You should use your common sense in deciding which is the best evidence and which should not be relied upon. That's what I'm asking you to do. It is common sense. You cannot rely on data that admittedly reports false data. How is that reliable? You cannot rely on testimony of witnesses who have changed their testimony, who have lied either at the first time or the second, because both of them were taken under oath. That is not reliable. You cannot rely on testimony from people who they work for a company who have a strong financial interest in convincing you that my client committed a crime and that their taser is completely properly working. There's nothing wrong with it. No bugs, no anomalies. Except, wait, that's exactly what I said under oath before. You should not rely upon that. Number one, did the witness seem to have an opportunity to see and hear the things about which the witness testified? Every single person who was on that scene, all those deputies you heard from, every one of them had the opportunity to see and know what happened. And not one of them told you that my client intended to discharge the taser. Not one of them told you they saw him do that. Not one. And they absolutely had the opportunity to see that because they're all in such a confined space. They're right next to each other. Number three, was the witness honest and straightforward in answering the attorney's questions? DeJesus had to be impeached. Deputy DeJesus, he didn't want to admit that he previously said that he saw spark as soon as he grabbed the bike. But we know he did say that. I had to impeach him on it because he changed his testimony. Childs certainly wasn't honest and straightforward. I had to draw every single answer out of him. It was very difficult to get him to admit that his taser, in fact, does have problems with it and that he did testify to that under oath previously. Did the witness have some interest? And now the case should be decided. Once again, Childs for Maxon, 100%. He told you it would be bad for his business if people thought that their flagship product, the Taser 7, the same taser used in this case, could go off by itself and report bad data. He absolutely has a financial interest in this because they pay his paycheck. That's how he makes a living. Does the witness's testimony agree with the other testimony, the other evidence? Once again, Childs, the data. Did you hear any other evidence that my client pulled the trigger and discharged a taser? None. They're asking you to rely exclusively on that data, which does not match up with any of the other evidence. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave? DeJesus and Childs, I won't repeat it. We've been over it. Rules for deliberation. Number one, you must follow the law. That's what you're asking you to do. Follow the law, use your common sense, and pay attention to the evidence that's been presented to you. Not assumptions. If you have to make leaps of faith, right, in order to find that a case has been proven, then it has not been proven beyond a reasonable doubt. And that is what you have to do in this case. You just have to say, yeah, I know we haven't seen any evidence that the trigger was pulled. I know no one said that Deputy Crawford ever deployed a taser, but, I'm just going to assume, You can't do that. You can't make a leap of faith like that. There is reasonable doubt in this case. And if you fail to follow the law, you're considered to be a miscarriage of justice. In this case, that's what we are asking for is the opposite. We're asking for justice in this case. We're asking you to follow the law and apply it to the evidence. I am confident that when you go back into there to deliberate and you review the law and you carefully discuss this case and you rely upon your own memory of the evidence, you are all going to come to the only conclusion that is reasonable under the facts and the evidence you've seen and the law while applying your own common sense. And that is that my client, Deputy David Crawford, did nothing wrong and is not guilty of culpable negligence. Thank you.
Thank you, Mr. Barber. Members of the jury, at this time, we are going to break for lunch. There is lunch waiting for you back in the jury room. I know that you picked that up this morning. You do not have to eat that in the jury room. You are welcome to do that. But at this time, we are going to break until 1:30.
Jury section.
And could we bring the jury in, please?
Jury centering.
Members of the jury, welcome back. I hope you enjoyed your lunch when you got outside, enjoyed the nice day in the fresh air. At this time, we are going to proceed with the state's rebuttal. Mr. Williams, you may proceed.
Thank you, Your Honor. You all have been very good. And this is going to be very anticlimactic because I'm going to be about 10 minutes. I have 2 pieces of paper. I'm going to go through these notes, then I'm going to sit down. And I'm going to start my succinct remarks by summing up the difference between the state's view in this case and the defense with something that the defendant or defense counsel said during their closing argument. And that was that if law enforcement acted the way the state wanted it to, our jails would be empty. The difference in this case is that the defendant is worried about jails being empty, and the state is worried about hospitals being full.
An objection as far as what my client wants?
Overruled.
This case is about reasonableness and the safety of law enforcement and what they do on a daily basis. It is not about permitting law enforcement to fill jails with people and making arrests. Over and over again, counsel stated to you, law enforcement doesn't have to do that. Law enforcement doesn't have to do this. The question is, should law enforcement do that? And should they do this? And the lucky thing for the residents and the people of the state of Florida is you decide. Because as the judge told you, policy violations are not law. The Osceola County Sheriff's Office and any other agency in the state can make any policy, they can train deputies or officers however they want. Because you all are the safeguards of law enforcement. You all make sure that law enforcement does what it's supposed to do. And how do you do that? By making sure they act reasonably. Whether another deputy believes that Deputy Crawford violated policy, whether he did it all, doesn't matter. Because you are the ultimate arbiters to make sure that law enforcement acts the way they're supposed to and doesn't put citizens at risk. It's really that simple. Now, it's a burden on you to make that decision, I recognize that. But it really is a decision that is that simple. And it's funny because when you listen to defense counsel's argument, it mirrors his client's testimony. I did nothing wrong. There's no reflection, no consideration, no second thought, no how can I do this better to make sure that people don't get hurt. It's, I have no obligation, I have no duty, I did nothing wrong. And is that a reasonable approach to take? Just generally in life, is that a reasonable approach to take, let alone when you are putting people's lives at risk every day? And I don't want anybody to misunderstand me. The state of Florida understands law enforcement has a very difficult job. And they are asked to do things that the rest of us don't want to do. We don't want to risk our safety for it. But that doesn't mean they can't and shouldn't think. Because that's another repeated over and over again. Muscle memory, we just do. No, you have to think. Law enforcement is trained to think. That training allows them to adapt to different circumstances. And when an officer, when a deputy decides he will not think, and he will do what he feels like doing, that is a violation of the law because it is not reasonable. And when it is followed up by actions that are culpably negligent, it's a crime. Now, I'm not going to go down every point that the defense mentioned, obviously, but I do want to point out a couple of sort of key, I don't know if they were misstatements or misremembrances, but I think they'll let you know what the true nature of the evidence is when I do that. So there's no evidence of intent. And then counsel kept saying, no witness testified to what his intent was. No witness can ever testify to what another person's intent was. The only way we know as humans what a person's intentions are is by looking at circumstantial evidence. What they said and what they did in the context of what was going on around them. That's it. And the reason the state of Florida is telling you there's evidence beyond a reasonable doubt that this defendant intentionally pulled the trigger is because there's no other way it could have happened. Because he disarmed the firearm in his right hand, the taser. He transfers it, and as he does it, he tells you what his intentions are. And then he arms it again. And then there's a pull of the trigger. How much more clear can you be about what a person's intentions are than what they say in the moment, right before they do the thing they did? No, they kept saying over and over again, defense counsel, the deputies all said he followed policy. No, that is not what they said. They were given generalities about training, and they agreed that in a vacuum, that is appropriate. So, for example, the deputies all agreed that when an armed suspect is being approached, using stealth is a good idea. No deputy came up and said that it was a good idea or within policy that David Crawford run up behind him and push him off a bike. And if you recall, defense counsel kept demonstrating you over, they're allowed to escort them to, that's not what happened. That's a complete mischaracterization of the video. The video shows him running up behind him and throwing him off the bike and screaming at him, get down, down on the ground. Get the F down on the ground. At one point, counsel was standing and he said, just got to put his hand, that's not what he did. Facts matter. The details matter. So think about that when you analyze the arguments that have been made to you. Then there's Mr. Childs. Mr. Childs is alleged in the defense closing to be a corporate greedy liar. And a couple of things about what was said. He also said, counsel said that there's evidence that the taser has a bug. And I remember that portion of the testimony because I was watching you all as Mr. Childs was trying to explain it. He kept saying, the taser is fine. The bug, if that's what you want to call it, is in the software that uploads it. And I don't know if counsel didn't understand the point, but they went back and forth, and I watched you nodding. Yes, the taser functioned, but the actual software counted something that wasn't there. And then he explained to you why it wasn't there, because it was 12 milliseconds, and humans cannot pull a trigger that quickly. And then counsel not so indirectly accused Axon and Mr. Childs of fabricating the data and said you can't rely on the data because it comes solely from Axon. Well, that's not true either, because the evidence is that before it was sent to Axon, in May of 2022, the sheriff's office downloaded the data. And it's exactly the same. And all of this has nothing to do with the fact that when you look at the actual discharge, that when he pulled the trigger that caused the fire, it's identical, and there's no problem. And even if you didn't believe the data, you know it happened in that moment because it's on video starting the fire. Think about the arguments that were made and the evidence that you actually heard, and not what the characterizations of it were. And then finally, with Mr. Childs, he was criticized for not opening up the taser. But he explained that too. He said, because the taser was working, why would I open it up? And then I love the example with the autopsy. Well, he didn't even do an autopsy. You don't do an autopsy on a live person who's doing just fine. You don't cut a person open if they're functioning and doing all the things they're supposed to do. And Mr. Childs didn't do that because he didn't need to. And lastly, as an example, is with Detective Panini, who I'll refer to as the fire marshal. Defense counsel said at least 5 times. He kept telling you that there was reasonable hypothesis, and that's reasonable doubt. That is not what Anthony Panini said. What he said was, there were 4 reasonable hypotheses, and I excluded and eliminated 3 of the 4. I'm not sure if he misheard or mischaracterized, but that was the actual evidence. And when those hypotheses are excluded with evidence, they're not reasonable doubt. The last thing I'll leave you with was the demonstrative that the defense used. Now, I would submit to you that this is not real world, and counsel was clear about that. But the important thing is to remember the way it was described 2 days ago. And he acknowledged this when the first description you all received, Mr. Barber was here and he kept throwing the firearm, right? He kept throwing the taser out. But what happened? The state of Florida admitted evidence of where the taser was actually found. And the reason that's important is because it very clearly shows he couldn't have thrown it anywhere. And the reason you can see the depth, see where the deputy had parked his vehicle? That's about the same distance from a pump that you would expect to see. If he'd have thrown that taser under the car, it'd be on the other side. The Camaro was right there. He never threw the taser anywhere. He was right here. He goes from his right hand to his left hand, and he discharges the taser right there, and he drops it right when the fire starts. If he'd have thrown it anywhere, it would have bounced off the car, which there's no evidence of. But what they told you the first time, before the evidence contradicted it, was that he threw it and it went off. If you recall, it was one of the many pin throws that went all the way across the room. And when confronted with evidence, the story changed. Just like we received additional evidence after the defendant was confronted with evidence. Now I didn't hear all of the radio traffic. There's a theme there. I also want to briefly address, well, if he wanted to tase him, he would have to point it down. Well, he didn't. And there'd be more, there's already 2 prongs. The taser can only fire 2 prongs. And what's important about all this is that all the photographs show the prongs were still in the victim. So he doesn't have to do anything but pull the trigger. And when you pull the trigger, it cycles. What the defendant did was go from his right hand to his left hand, he armed it, and then he pulled the trigger and it cycled. And when he did that, by that time the fuel vapors had gotten there and everything burst into flames. And the last thing I would point out is, well, the taser would be damaged. It would be on fire if he'd had it in his hand. His arms and hands were never on fire. You saw the video. His legs were. Right? There's no fire damage to any of his hands or arms. That's why. His legs got caught on fire. He panics, rightfully so, disarms it, drops it, right there where the whole thing happened. And then he stops, drops, and rolls. Which is all consistent with the evidence. And completely inconsistent with what they told you. Told you 10 minutes. The choice is yours. You all have to decide first, was what he did reasonable? For all the reasons we've discussed, I believe there's overwhelming evidence beyond reasonable doubt it was not. A decision that is reasonable allows law enforcement to go unchecked. And then, once you decide that it was not reasonable, Did he display a conscious indifference? Was he reckless towards public safety? And not just Jean Baretto-Baerga. Everybody there that day. And the answer to that I would submit to you is yes. And the answer based on the evidence and the law is in your verdict form, and we would ask you to return a verdict of guilty as charged. Thank you.
Thank you, Mr. Williams. At this time, I'm going to release our alternate juror, Juror 5466. You are actually free to go at this time. You're welcome to stay in the courtroom if you want to. You're certainly free to go as well. I do have a certificate for you here. I'm going to ask the deputies to hand that to you. Do you need to get things out of the jury room? Yes. Okay, so then I'll have them walk you back to the jury room and then show you out if that's what you wish to do. Okay, thank you so much for your service. You may. Members of the jury, in just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violations of these instructions or any instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have cell phones, laptops, tablets, or other electronic devices that you've had throughout the trial. When you return to deliberate, there's a bin that's outside of the jury room. I'm going to have you place all of your electronic devices in that bin, including your Apple Watches. When you are in there deliberating, there will be a deputy sitting outside of the room, so your possessions will be taken care of while you're in there, okay? If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The following exhibits will be sent into the jury room with you when you begin to deliberate. All of the state's exhibits numbered 1 through 25 and Defense Exhibit 1 for the limited purpose outlined in the jury instructions. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So at this time, I'm going to ask that you retire to deliberate. I'll have the deputies escort you back to the jury room.
Jury is excellent.
Will you grab that? Thank you. Okay. Jeff, here's the verdict form. And then The evidence needs to go back. Mr. Williams, did you have a laptop?
We do.
Okay. Yeah.
Your Honor, there's one very minor issue. I don't think it changes anything, but you did say 1 through 25 on exhibits. I believe there's only 22.
There's 25.
Okay, sorry. The version we have here said 22.
Because we did those
That,
before the afternoon yesterday.
That's right. Sorry, Judge. That's why I didn't say anything before, but I'm like, we'll just address it after. It's probably just something small.
It's correct.
All right. Thank you, Judge.
Thank you. Thank you. Did you get like the helmet and? Where is it? Yes. Oh, yes. All right. So I'm going to go into recess at this time. It's my understanding that the jurors have a question. Counsel for the state's present in the courtroom along with Mr. Crawford and his counsel. Could you get a question for me? Oh. Okay. The question is, in definition of culpable negligence, can you further define gross and flagrant sentence 5?
I don't believe we can, or I don't think there's not the definition I have. It's a state position.
Mr. Berger.
It's always hard with these, there's no statutory definitions, Judge. I'm not sure how we could define it at this point. That's why I wanted the case, the language from the case law that I had brought before the court, but I don't know how we can define this for them now, Judge. I don't think we can.
I do not think
Yeah.
we can either. Instead of bringing the jurors back in, do you mind if I respond in writing to their question?
No objection.
I have no problem with that.
And I'll let you guys take a look at it before I send it back.
Thank you, Your Honor.
I'm unable to answer this question. You are to rely upon the jury instructions that have been provided to you.
No objection, please.
No objection, agreed.
Once they read it, will you collect it? Thank you. No holding and such. Highlighters, please.
No objection.
No objection.
Okay. Do we have, I would have to call her though and ask her if she can find us some highlighters.
I have one, Judge.
I have
brought
one.
Yeah.
It's never a request I've received, actually.
We all pitch in.
I heard that's what whiteboard once.
Did you really?
We found one. Judge,
Are you good?
Yeah.
I don't know. Okay, well, I will just wait a few more minutes here to see if. Yes, thank you. question is, can you please use your mobile devices to communicate with our homes on child care arrangements? So yes, they can. We'll bring them in here, and then, things, I mean, even if they were use the court phone, I don't know if they want phone number.
One is still using the restroom, Judge.
Well, the one thing they could do, Judge, is if they come in court, and then maybe they can turn off cellular, look up phone numbers, route the numbers they need, and then use a court phone maybe. Because obviously they need childcare, I'm just trying to make sure that we don't accidentally get into a situation.
Right, I mean, obviously I'm saying that they are allowed to communicate,
Oh,
to make
of course.
arrangements for their children. I just don't know how best to facilitate that.
The way I've seen it done is just have them one at a time step out, have the deputy present for the phone call to make sure that they are listening. It's not related to the case.
I'd be fine with that, Judge, that seems sufficient.
Okay. We'll do that then, that works. All right, so in terms of the exhibits that were marked for identification, but were not entry into evidence that have been in the jury room, what suggestions do you have to handle that issue?
I need to do some research. Is the answer to that?
I was going to say the same thing, Judge. I was probably going to do some research, maybe make some calls. I've never come across this issue.
Well, what about this? What about, because well, the jury's going to come in. What about removing everything from the jury room?
Yes.
Jury Editor?
And also to ask for the staff.
Oh, yeah, well, we can go in and just stare at them.
Where's the jury? I just received your question about being able to communicate with your families regarding childcare. That is not a problem. The way that we'll handle that is we'll have each of you step out, whoever needs to do that, one at a time, with the deputy present, to allow you to use your phone and do that. We recognize that this day and age, we might not even have everyone's phone number memorized, so I understand you might need to use your phone to do that. The other thing is at this time, there's a legal issue that has come up that we need to address here in court. So I'm going to ask the deputies to remove all of the evidence from the jury room. And I'll allow you to go do that before I have the jurors go back into the jury room. And while he's doing that, I'll have you return back to the jury room while we discuss this issue. But during that time, I do not want you to continue your deliberations. Okay, I'd like you to stop deliberating for the time being until we bring you back into court and instruct you further. Okay? Just wait for Deputy Diaz to bring back the evidence. Or is he going to put it in the locker? Thank you.
Yes.
I just have a brief question about the communication, only because I know my husband and he never answers the phone.
Okay.
So if we try to call and they don't pick up, are they able to observe if we write a message to read it and send it? Is that allowed, or is it just a phone
Oh, you
call?
want to send a text message?
Yes, because I just, yes. Is that
Any issue with that? Yeah.
Okay.
And it would be the same as if you were taking a phone call, the deputy will be observing.
Okay.
Do we have the helmet?
I think I can put on a chair, right?
Yeah.
Deliberations.
Yes, so one by one, those things need to come out and you circle in front of one of you.
Just a point of hold.
Right, just where their items are.
person I was hoping to ask a question about this.
Okay.
Thank you.
Go ahead, Mr. Williams would like to speak.
Judge, I feel confident, and I know what the law is on this. I would cite according to Hamilton, which I'm sure was already done, maybe.
I have that, and I have one.
Right, so the state's position is that the law says we need to know basically what was admitted and what influence it had, if any, over the jurors. So the reason I asked Mr. Barber to come back in is I think we need to look at the evidence, find out what impact it was supposed to, and then examine it to see, again, as I said, highlighter questions what made it think in my mind. So if there's a document that's been highlighted that was supposed to be admitted, I didn't need that, because that'll help us go forward.
Correct. So I'm going to send you all the Williamson here. I don't know if you've read it or not, but
I have not.
I don't think Mr. Barber has, but I think it's pretty much right on point with the situation that we have right now. And it pretty much lays out the procedure, and I think we can, once everyone's had an opportunity to read it, we can take it from there.
Yes, Sean. Thank you.
By the state. We that is clear on.
Look at my list. So, today was the that was the actual that we showed, and I use that just for impeachment purposes only. Defense B was the receipt from Wawa, which was never entered because Mr. Baretto-Baerga never testified. Defendant C, deposition transcript of the arson investigator Kennedy was never needed. I never needed to impeach him. Defense D was a deposition transcript of Brian Childs, where I did use it for impeachment.
And then F was the map of Osceola County. I know that.
Yes, and then F was the map. Sorry, even after that on my list. Yes, was the map. That was just demonstrative.
Okay, and then what I have for the state's items that were marked for identification but not placed into evidence would be the Osceola County Sheriff's Office policy, response to resistance, Defendant Crawford signed Taser training documents, documents certifying Defendant Crawford received the RTR policy. Did I miss any?
There was just one page that should have been attached to the rest, which was a certificate of completion of a course that he took the acts on.
What was that marked as?
AA.
Okay. That's a certificate of course training?
Mm-hmm.
Okay. All right, so those are the items of evidence that were included in the items that went back with the jury. I just emailed you all that copy, the copy of Williamson v. State, 894 2nd 996. Just take a moment to review that, and then we can talk about it. You're finished?
Yes.
Okay, all right. So having read the case, were you moving your chair, Sienna? Okay. I think the first question I would have is if the defense was requesting a mistrial.
That is what I need to step outside and make a call for, Judge, because I need to find out for sure whether I need to request a mistrial to preserve this issue for appeal. There's a lot of these issues that you do, and I just want to be 100% positive before we go there, Judge, if I could have a moment.
Okay.
Thank you, Judge. May I step outside, Your Honor?
Yes.
May my client join me?
Yes.
Thank you.
All right, we're back on the record. Counsel for the state is present along with Mr. Barber and Mr. Crawford.
Judge, is it possible to bring the jury in and ask them whether they've even viewed any of this stuff before we make a decision as to whether we want to request a mistrial or not? Because we don't really know any prejudicial effect at this point. So I was hoping we might be able to inquire.
Here's the thing, you can want to respond, but in order to determine whether or not we're going to mistrial, I would question the jurors about what they think.
Right, which is why Your Honor probably asked whether there's a motion, because if there's no motion, there's no need for a lengthy inquiry. So,
Judge, how could I possibly determine a prejudicial effect without knowing they've even seen it?
Well, at this point, we're going to bring the jury in, and we're going to talk to them about, well, before we do that, so would you like to look at the items before the jury comes in? Because I just went through them.
yes, we would.
So here are the items that were marked by the defense. And here are the items that were marked by the state.
Self-defense is something easy as well. Yeah, if I could, I just want to flip through it. I don't see any highlighted issue, parts of this. It doesn't
Well,
really.
I just before you start.
Yes, sir.
So would the state agree that there are no markings on any of the documents that went back to the jury that appear to have been made by the jury?
They agree, Your Honor.
Would the defense agree with that?
Yes, Your Honor.
Okay. Would the state agree that the materials that went back to the jury that were marked for identification dealt with the facts of the case and not the law of the case?
We do.
Would the defense agree with that? Were there any items that were sent back to the jury that explained the law or had to do with the law and not with the facts of the case?
Not the law, the policies that are judged.
But that's not the law.
I understand.
Okay.
No.
So do you agree?
I agree. There's nothing about law that would, well,
Tell me specifically then, please, which item went back to the jury that has to do with the law and does not have to do with the facts of the case?
the Taser warning document has a liability release portion on it. It doesn't have to do with the law of this case, but it is legal statements. That's the only thing I can think of, Judge. I don't think it's the law in this case, but
Okay. Right, but you would agree with me that there were no materials that went back to the jury that had anything to do with the applicable law that the jury is to apply in this case?
yes, Judge, I agree.
All right. So then, at this time, I am going to bring back in the jury. I'm going to begin questioning them, and then based upon what I ask, if the parties have any additional questions, we'll go that way.
And I would ask that any questions by the parties be proffered to the court before they're asked by reviewers.
Agreed, Judge.
Could you bring the jury, please?
Yes.
Thank you. Do you have?
Jury entry.
Where's the jury? It was brought to my attention that some items were sent back into the jury room with you that were not actually entered into evidence. So at this time, I need to ask you some questions about whether or not you are aware of those items, and if you reviewed them, and if you've considered them, okay? The items that were sent back into the jury room that were marked for identification but not entered into evidence. And I think what I'll do, if I could just have you say, I'm going to start on my left side, I'll just have you say your juror number. I'm going to read the item, and then I'll have you answer if you were aware that it was there and if you reviewed it and considered it. Does that make sense?
Yes.
Okay. The first item was what was marked as identification as states T. It is the Osceola County Sheriff's Office Policy 470.0 response to resistance.
Yes, I reviewed it.
Okay, could you tell me your juror number, please?
487.
Okay, sir?
170,
No, you did not.
I did not.
Okay.
588, I was aware it was in the room. I think a section of it might have been read out loud, but it was not taken into consideration.
Okay.
203, I was aware and part of it was read out loud but not taken into consideration.
Okay.
277, same.
Okay.
76 the same.
Okay. The next one was marked as State View, and it is Defendant Crawford's signed Taser training documents.
Yes, I reviewed it.
Okay.
It wasn't taken into consideration.
Okay. Would you just tell me your number again?
487.
Thank you. Sir?
170, and I saw it, but didn't think much of it.
Okay.
588, saw it, did not consider it.
203, I viewed it on the table, but not considered.
277, same.
Same.
And would you just tell me your journal number?
76.
776?
76.
7. Okay. And then what was marked as states V would be the docket certifying defendant Crawford received the RTR policy on January 13th of 2022.
487. I'm not aware of it.
Okay.
170, no, I didn't see that.
Okay. 588?
588, I'm not aware.
203, I was not aware.
277, not aware.
Okay.
76 not aware.
Thank you. And then there is what was marked as states AA is certificate of course training. Juror 487?
No, I'm not aware of it.
Okay.
170, not aware.
588, not aware.
203, not aware.
277, not aware.
76 not aware.
Thank you. And do I have the defense's report?
Oh, I apologize. I think I still have no council table. I mean, I approach on it.
You may. Thank you. All right, and so what was marked for identification as defense exhibit A but not entered was Deputy David Seuss's interview. Juror 487?
I don't believe I saw that.
Okay.
170, not aware.
Okay.
588, not aware.
203, I didn't see it.
277, not aware.
76 not aware.
All right. There's the, what was marked as defense exhibit B was the Wawa receipt.
487 saw it, did not consider it.
Okay.
170, not aware.
588, yes, I looked at it, but not considered.
203, I saw it, but not considered.
277, saw it on the table, but not considered.
Thank you.
76 I hear about it, but did not see it. Not
Thank
considered.
you. Okay, thank you. What was marked as defense exhibit C was the deposition transcript of the arson investigator.
487, yes, I did see it, I read it, and I was considering it.
Okay.
170, didn't see it.
588, I believe that was the document that was read out loud, and if so, then yes, it was being considered.
Okay.
203, it was being read aloud by another juror, and we were considering it.
277, same.
Okay.
76 the same.
Okay, thank you. And then what was marked as exhibit D was the deposition of Mr. Childs.
487 read it and was considering it.
Okay.
170, I was aware of it.
588, I was aware of it, had not yet read it.
203, I knew that it was there, but I had not viewed it.
277, I was aware and did not view it.
76 aware but did not read it.
Okay. And what was marked as defense exhibit F was the map of Osceola County.
487 saw it, did not consider it.
170, saw it, wasn't considering it.
Yeah, 588, saw it, did not consider it.
203, I didn't see it.
277, saw it, didn't consider it.
76 saw it but did not consider it.
Thank you. Is there any need for any of the lawyers to approach at this time?
Nothing to state.
Okay, just one moment, Judge.
Sure.
Yes, Judge, may we approach?
Sure. Members of the jury, at this time, I'm going to send you back into the jury room. You can begin your deliberations again. You are not to consider any of the items that were inadvertently sent into the jury room with you in your deliberations. Do you all understand that instruction?
Yes.
I see everyone nodding their heads or saying yes?
Yes.
Okay, all right. Thank you very much. The deputies are going to take you back into the jury room.
Where's second?
I have everything that cannot go. And these were separate. I think they're the same one, but I want you to go that this goes with this. Or if it's separate, because this isn't marked and it's pre.
We tagged them, and then we tagged them.
Okay.
They're one composite.
Okay, I just wanted to make sure before. It looked like it came from, it's all part of the same document.
Well, there are two tags
Oh,
on
not
it.
that.
Oh,
This.
I think these are the two different versions. So that would probably go on the back of this one, Judge, because this one has the tag.
They must have had
And they were
it out.
separate.
I believe, right, we could agree that probably.
I just,
Okay, just wanted to check with y'all.
I'm just, yeah.
I don't have a feeling or a comment about
I know.
it in any way.
For us, though, I know the clock's ticking, you know, and that's not due to anyone else. That's just a practical matter of how juries work, how jury trials work. You want to get a verdict or some mistrial. But if we could go back out and keep talking, Judge, we're going to try to get an answer to that as soon as possible.
Okay.
Thank you, Judge.
Giving eye.
Okay.
So she has to go on her map and go on a link to register for whatever she's registering. And I said, you said as long as the deputy can be with him and observe what she's doing, that's okay.
It's a specific website for a
So,
camp?
yeah, for a camp.
No objection so long as there's observation.
Same, Judge. No objection. That's what I assumed we were discussing last time.
Right.
She could go to the website.
So another juror chimed in and said, well, can I text my husband to say I'm going to be late? And I said, well, I think so, but I'll check. As long as the deputy is doing the same thing as they did with the other one.
That's correct.
I agree with Judge. Yeah, no problem.
Thank you.
Yes, ma'am.
present, Mr. Williams and Ms. Walker, also Mr. Barber and Mr. Crawford are present. We received a question from the jurors. If the jury is unable to reach a unanimous verdict, can you please advise as to what happens in that instance?
I know there's the charge we can give a judge, but just based on my recollection, Judge, that's the only thing.
So,
there's that one specific charge.
The question, though, that I'm reading, they're not telling us that they cannot.
You're asking what happens if they do.
Correct.
I've never, that's, I'm sorry for saying, I've never had it phrased that way, so I'm gonna look.
Sure.
I agree. That's kind of a unique wording of it.
I mean, I do know that I'm not sure which instruction you received, but there is an instruction
I
that
have
tells
one.
them that it's, that tells them that a mistrial is a horrible expense, et cetera, but that's obviously a different context.
Right, so I can tell you guys, if you agree, it's just the way that the question is phrased to me doesn't sound like it is that they are unable to reach a verdict necessarily. I don't know. So this is a jury instruction. It's jury instruction 4.1. I can read it to y'all. It reads, I know that all of you have worked hard to try to find a verdict in this case. It apparently has been impossible for you so far, which I don't know that that's true. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it is legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is, as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back to the jury room. Then, taking turns, tell each of the other jurors about any weaknesses in your own position. You should not interrupt each other or comment on each other's views until each of you has had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your services. You may now retire to continue with your deliberations. That's the deadlock instruction.
What is the instruction again? I'm not asking you to read it.
No, 4.1.
4.
I'm unaware of any other, because this is the Allen charge, right? This is what the Florida Supreme Court has given us as the Allen charge. They're worried about.
This is the standard jury instruction.
I'm not sure. I don't think there's any variance we can get on this today. Of the law. Yeah, I'm sorry, Judge. Yeah, I mean, I'm not aware of any other instruction that can be given to a jury in this situation.
Do you believe it to be appropriate for the court to read the instruction to the jury at this time?
Can you just read the question one more time, Judge? I know it was short, but.
Sure. If the jury is unable to reach a unanimous verdict, can you please advise as to what happens in that instance?
Yeah, I think it'd be appropriate because at the bottom of it, it does tell them what would happen. So, yeah.
So yes.
Yes, Judge.
Okay, so no objection to the court reading the instruction at this time.
No objection, Judge.
Okay. And can we bring the jury in, please? Members of the jury, I have received your question and discussed it with the lawyers here in open court. At this time, I'm going to read you the following instruction. I know that all of you have worked hard to try to find a verdict in this case. It has apparently been impossible for you so far. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it is legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem and not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict, if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back into the jury room. Then, taking turns, tell the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's views until each of you has had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your services. You may now retire to continue with your deliberations.
Are we going to receive a copy of any of that, or like what you read? There was just one section in there about like evidence versus this, like that one piece.
You would like a copy of the instruction I just read you?
Yes, please.
Okay.
If that's possible.
Any objection from the state?
No, Your Honor.
Mr. Barber?
No, no.
Okay. We will have that back to you very shortly.
Okay, thank you.
Thank you.
Jury secretary.
Okay. Mr. Williams, could you help me out? I left my computer downstairs. Would you please, or would you email it to the clerk so that she can print that for you?
Do you have a card or do you email?
I can give you my.
Sure. No problem.
excuse me, we are back on the record in 23 MM 3655, State of Florida versus David Crawford. I have counsel for the state present in the courtroom, Mr. Williams and Ms. Walker, along with Mr. Barber, Mr. Crawford. It's my understanding that the jury has reached a verdict. Could you bring the jury in, please?
Jury's entering.
It's my understanding you've reached a verdict.
Yes, Your Honor.
Could you send that to the deputy, please? Madam Clerk, would you publish the verdict, please?
In the County Court of the 9th Judicial Circuit and in 4, Orange County, Florida, case number 2023 MM 36550, State of Florida versus David Thomas Crawford. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this 22nd day of November 2024.
Thank you, Madam Clerk. Ladies and gentlemen, I wish to thank you for your time and consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. I want to sincerely thank all of you for your time and attention this week. And at this time, you are discharged and you are free to go. In just a moment, I'm going to come back and hand out your jury certificates if you'll just wait for me for just a moment, please. Thank you very much.
Please rise. Jury's entering.
Jeff, will you grab the badges for them from them? Thank you. You may be seated. Okay, so at this time, Mr. Crawford, you have been found not guilty by a jury of your peers. At this time, I adjudicate you not guilty. You are discharged and you are free to go.
Thank you, ma'am.
You're welcome, sir. With that, court will be adjourned.